Here for the fourth and the last technical section of this conference. This session has the main focus on transforming legal education for the future, a roadmap, with a special emphasis on its sub-theme, molding the future, legal education reimagined, rethinking legal education. We are blessed to have amongst us Honorable Ms. Justice B.V. Nagaregna, Judge Supreme Court of India, to chair this session, who has graciously consented to chair the session. And we have Honorable Mr. Justice Prashant Kumar Mishra, Judge Supreme Court of India, as co-chair, and Honorable Justice Tan Sri Dhuduk Nalini Padmanabhan, Judge Federal Court of Malaysia, to deliver the keynote address. Before commencing the technical proceedings, to do the honors, may I request Dr. R. Venkatramani, Learned Attorney General of India, and Professor S. Shivakumar, President CLIA, to come over to the stage. Honorable Ms. Justice B.V. Nagaregna, Judge Supreme Court of India, who is the chair of the session. May I request Professor Shivakumar sir to join in honoring the guest. Honorable Mr. Justice Prashant Kumar Mishra, Judge Supreme Court of India. Honorable Justice Tan Sri Dhuduk Nalini Padmanabhan, Judge Federal Court of Malaysia. Thank you, sirs. May I request Mr. Vikramjit Banerjee, Additional Solicitor General of India, to give your introductory remarks and welcome the gatherings.
Thank you and welcome to this fourth session. And we have wonderful speakers, including the Honorable Justice Nagaratna, Justice Prashant Kumar Mishra, and Tan Sri Dhatuk Nalini Padmanathan. It's a wonderful topic on legal education and what it should be in the future. I come from a law school where I think Sudhir Krishnaswamy was alumni of that. And it was a wonderful experiment in India. And it was based on a lot of models which were then existent. So we are looking forward to a wonderful interaction and what new ideas may come our way. Thank you and welcome everyone.
May I request Honorable Ms. Justice B.V. Nagaregna, Judge Supreme Court of India, to deliver your presidential remarks.
Namaskar and a very good afternoon to everybody. Honorable Justice Prashant Kumar Mishra, my learned brother and colleague of the Supreme Court, Honorable Justice Nalini Padmanathan, Judge Federal Court of Malaysia, learned Attorney General for India, Sri Venkatramani, Sri Tushar Mehta, learned Solicitor General, learned Attorney Generals from the Commonwealth, learned Solicitor Generals, learned Advocate Generals, Senior Advocates, distinguished guests and dignitaries, my esteemed panelists on the dais, esteemed discussants, and dear students, ladies and gentlemen. This session is very important for the conference. It is on transforming legal education for the future, a roadmap. As we all know, legal education is more for public good rather than private good as compared to other areas of higher education. We in the Commonwealth are all governed by rule of law, and therefore legal education assumes significance and importance because promotion of rule of law and maintenance of good governance with citizen participation and protection of basic human rights must ensure that there is a body of legal professionals trained in law who can manage the legal and judicial system. Legal education consists of different types and of varying objects and functions in the society. In the normal terms, it is understood as professional legal education, which must educate students and train them for the highest possible levels of knowledge and skills, which requires collaboration between academics and the practitioners. But there's also what is known as non-professional legal education, which is gaining momentum, where there is academic pursuit, not so skill-based or rigorous, but more focused on teaching and research, which involves multidisciplinary scholarship and analytical abilities of a different kind as compared to practicing lawyers. There is also a third type of legal education which is gaining momentum, and that is continuing legal education for those already in legal practice who find the changing legal scenario too complex to address through self-study alone. As such, there is no organized system of continuing legal education as such, and I hope that this conference would evolve certain trends in that regard as to keep pace with economic liberalization, technological development, and globalization for already those who are in the practice of law. Legal education must also focus on producing adequately trained personnel for managing the legal and judicial system, which again depends on the demands of the legal market as well as the expectations of the society concerning justice. Since the theme of this conference is with regard to transforming legal education for the future, a roadmap in this session, and on cross-border challenges in justice delivery, I must emphasize that legal education must focus on access to justice, quality justice, cost and timeliness of having justice. As far as academic education is concerned, it is to enhance legal awareness, legal research, training and development, and the promotion of rule of law, but in both streams, the emphasis must be to bridge the gap between law and justice. I must say that we, who are all from the Commonwealth countries, must have a national policy in our own country on legal education, imbibing the best practices from various other countries. I must say that with economic liberalization, globalization, the legal profession is increasingly becoming specialized and diversified beyond recognition. It is moving away from court-centric or litigation-centric practices and the entry of arbitrators, mediators, conciliators in various streams or fields, and legal professionals also intertwining with them, calls for competition in work, and interprofessional cooperation therefore becomes necessary for better delivery of legal services, compelling changes in the way the profession is organized today. Legal education system must take note of this change, as it is bound to grow intense and complex, which would demand different skill sets, knowledge, and even ethical standards from lawyers. But alas, law schools and colleges are unable to cope with this market demand. The economy is changing fast. Therefore, the policy of professional legal education requires reorganization in terms of specialization and domain expertise, instructions on subjects outside law, if it has to provide employment opportunities for students and promote economic development agenda of the country. Another area of importance is with regard to advancement of constitutional goal of social justice and social transformation. Hence, we require alternative curricula for producing community lawyers and even paralegals to address the problems of the poor and marginalized sections of the society. The national policy of professional legal education in the countries must therefore provide for specialized law schools and people-oriented curricula for creating a cadre of legal professionals competent and motivated to take legal services appropriate to the problems of the needy in the countryside. Professional legal education curricula must therefore be skill-based, multidisciplinary, and having a basis in the social context. I must say that with the advance of technology, the lawyers are more and more tech-savvy for effective delivery of legal services. Law students depend heavily on online database, and therefore legal education must find a balance between the technological process and human development in the scientific age, and therefore law colleges must create a body of professionals comfortable to deal with the challenges that technology poses to existing legal arrangements and achieving fairness in society. As far as the faculty in the law colleges are concerned, I must emphasize that the diversity and inclusiveness of faculty and student bodies and the extent of international linkages would count a long way for academic excellence. Everything revolves around the competence and commitment of the teachers and researchers, constituting the driving force in higher education. With the surge in demand for legal professionals, law schools established in India are actually islands of excellence, but in a sea of mediocrity. Teachers' competence, commitment, and accountability have become key factors in determining excellence in learning outcomes across all educational programs. Therefore, when it comes to legal education, we have to review and revisit the eligibility criteria and requirements of law teachers, job specification and selection processes of teachers in the legal stream. Steps must be taken for faculty development and strengthening of research and training capabilities of law teachers through various measures. Side by side, there must be innovation in the curriculum and the legal education, which generally depends upon jurisprudence, must also emphasize on interdisciplinary approaches and problem-solving methods of learning, which must lay less emphasis on classroom teaching and more on field-based studies. In my view, after the 3-year or the 5-year law course, there must be 1 year spent as a finishing school, which must focus on 4 areas of the legal profession or the legal world, so to say. And I would emphasize these 4 areas as such. Firstly, to prepare students for the legal profession. Second, those who want to get into legal academia. The third, to encourage students to become judges, because in India, even after the law colleges, the students are eligible to take the exams to join the judiciary. And the fourth is to train students for non-litigation practices such as the corporate world, mediation, counseling. That kind of focus or a finishing school would give the law students an idea as to where they would like to really enter, rather than all entering the bar and then wondering as to where else they would go. Lastly, I would like to say that globalization is the process of development. The best practices obtaining in other countries must be adopted by India for best results. Lawyers must be familiar with laws of other countries. The legal education must respond to the demands of the emerging areas through internationalization of faculty, students exchange, and course content, smart classrooms, digital library, ADR laboratory, etc., which should be not only in India, but throughout the Commonwealth countries. Ultimately, in my view, the character of the law schools determines the character of the bar and ultimately the character of the bench. Legal education must therefore respond to the call of justice, social, economic, and political. Today, for tomorrow, may be too late. Unless steps are taken to strengthen public good through our responsive legal system, sensitive towards people's needs, justice is going to be a far cry. I will end by saying that at the end of the day, it is necessary to recognize that the study of law is fundamental to the study which, after all, has justice as its main goal. Law without justice is as hollow as Beethoven without music or Ramanujam without mathematics. The study should be to bridge the gap between law and justice. With these few words, I thank Honorable Justice Suryakant for giving me this opportunity, and along with Mr. Venkatramani, the Attorney General for India and the Solicitor General for India and his team for giving me this opportunity to chair the session and share a few of my thoughts. Thank you very much. Namaskar.
Thank you, Honorable Justice, for enlightening the gathering and opening the House for further discussions. May I request Honorable Justice Tan Sri Daduk Nalini Padmanabhan, Judge, Federal Court of Malaysia, to deliver the keynote address.
Honorable Chair, Honorable Co-Chair, learned speakers on the dais, and learned delegates. I won't go into the details yet, or the honorifics, and of course, importantly, the students. This is very much a topic for the students, so it's nice to see so many of you here. If I do nothing more in my 10 minutes, I would like to summarize the key features I feel are important in future legal education. Firstly, the need for the legal education curricula to educate students on the changes to and evolution of substantive law, as opposed to procedural, brought about by the digital revolution. Secondly, the need to ensure that legal education weaves into its fabric the vital importance of access to justice, as the learned chair has just said, and the need for citizens at all levels of society to enjoy this basic fundamental right. This basic right seems somehow to have taken second place in this increasingly globalized world that is primarily focused on profits. Thirdly, future legal education should focus on the need to decolonize the mind and to ensure that laws of a nation meet the needs of its own citizens at all levels of society. Fourthly, in relation to cross-border law in justice delivery, to address the need to level the playing field such that harmonizing laws are equitable and, more importantly, are applied equitably. I'll start with substantive law, the future. When speaking of the future of the law and legal practice in the 21st century, it's a well-known truth that we are in the midst of a digital revolution. It would be a mistake to think that that comprises a mere shift from bricks and mortar courtroom to a virtual medium. It is much more than that. Digitalization has touched on how we work in terms of strategy, structure, work processes, capabilities, and culture. The greater future challenge for the law and education in the law lies in how substantive law is to evolve in the digital age, as must the actors who operate in the field. How the rule of law is adhered to must accordingly be adapted to meet the needs of this era. The theory and teaching of law should also adapt to these altered conditions. Such change should be made at a philosophical level, not merely by a superficial compliance with the technological aspects of the digital era. For those of you who are students here today, that will be like a duck taking to water, for you're all children of the digital age. You are born into it, and it is second nature to you. So you are in the very enviable position, I suppose, to fashion and create the future of the law and the path it takes. It is important that you take it in the right direction. Coming on to more concrete examples, data is becoming central to economic activity, digital currency, as we heard this morning, the utilization of cryptocurrency. The law and legal education will have to evolve to meet these new areas which are crucial to daily life. The rise of the platform economy, which involves the digitalization of products, services, and business processes in sectors such as transportation, accommodation, retail, and banking sectors, is yet another example. Legal education will require updating to bring it in line with current technological advancements. And solutions will have to embrace cross-border concepts, because what is all right in a domestic setting may not be so on a cross-border level. Digitalization also means that the performance of routine and lower-level tasks will increasingly be assisted by or eventually replaced by technology, forcing lawyers to hone their skills in the important higher-level criteria of understanding, applying, analyzing, evaluating, and creating solutions for their clients. To meet these changes, legal education will also have to shift its format and content and thrust. As highlighted by the Honorable, the Chief Justice of India yesterday, in order to enhance these skills, particularly intellectual engagement, the ideal learning environment should mimic the complexity of real-world tasks and work that will later be performed by the students, and as mentioned by the chair just a few minutes ago. So legal education must metamorphose to meet this need. I move on to the importance of access to justice and how legal education can address this and why. As Richard Susskind put it, people want justice, not lawyers. So perhaps the focus for both legal professionals and law schools should be how to achieve justice rather than producing mere lawyers. So you might ask, why is this access to justice so important? The answer lies in the manner in which the profession of the law has changed in the last 50 years or so, largely due to globalization. I, of course, speak from my perspective, the Malaysian perspective. Now, it cannot be said sufficiently that globalization has greatly facilitated the legal profession, but it has also altered the structure of the law and its manner of practice by professionals. The reality is that business has become a colossal power. It is internationalized in countries throughout the world, while power is concentrated in specific regions. The 80s onwards saw a huge expansion of these transnational corporations. They are virtually like private sector states, making their own transnational regulation, modes of operation, and new fora for litigation, arbitration, etc. These transnational corporate superstructures took along with them their large corporate law firms, largely Anglo-American, which accordingly also metamorphosed to accommodate their clients' needs. Legal firms then across the globe accordingly expanded along similar lines to ensure survival and to boost their earnings in future. Together with this alteration in structure, geography, and culture, law firms, and again, this is largely about law practitioners because that is my background, both domestic and transnational on their clients, there was a gradual dismantling of the more traditional structure and practice of the law. What was initially, in the 19th and early 20th centuries, a profession which was connected closely to state theory, political values, and a specific ideology which focused largely on comprising the cement between the state, society, and citizen, changed to assume the needs of the modern globalized society. Along with this change came the reality that the concept of access to justice in the practice of the law became less important. Maximization of profits became key, which left little or no time for pro bono work or other contributions to society. So in that sense, the DNA of the professional lawyer and law firms were effectively altered. And of course, the lines between legal professionalism and commerce were encouraged to be blurred. So that, of course, affects the standards of ethicality of the profession. And that's where we are today. So there's naturally far less recognition of the intellectual, moral, and cultural authority of lawyers and the profession as a whole, which was once enjoyed. So please don't get me wrong, I'm not saying that globalization or earning very comfortably from the profession is wrong. What I am saying is that it cannot be at the expense of the complete erosion of the fundamental building blocks of the profession. And those foundational aspects lie in the importance of comprehending the composite nature of the law, which has room for concepts like equal access to justice and the profession's responsibilities to society as a whole. And that's perhaps the crux of legal education that should underpin any understanding or practice of the law. That is a value that has to be embedded in the teaching of the law, and law schools perhaps comprise the most important starting point, although it's something that ought to be practiced throughout one's career. To instill the notion that while the law enables the pursuit of economic prosperity, legal education can teach that there is a need to be mindful of and comprehend the need to address economic inequality. That translates for the legal profession to allowing for access to justice by helping out. Now, the third point, the need to decolonize the law. Very quickly, on what I term the colonial mindset. Colonialism has shaped our lives. Again, I speak from the Malaysian experience. Malaysia, as an independent nation, is physically free from the former strictures of colonial powers. But to my mind, we have not completely divested ourselves of the colonial mentality that endures in the collective legal psyche. Colonization of the mind, what do I mean by that? Simply that our legal thinking is subconsciously imbued with the notion that the law of our colonizers is somehow superior to the laws of any other land. While not necessarily true, this was a virtual inevitability as a consequence of colonization. As such, English law became the measure for what is deemed an acceptable system of knowledge. It ring-fences the boundaries of acceptable forms of rationale, expression, and thinking, some of which still persist till today. So it needs to be said that in a globalized world, there is no basis to contend that any one system of law or that any one body, be it from the global north or the global south, has the monopoly on legal thinking or defining the correct law that is to be relied upon globally by all nations. And that is a reality that has to be inculcated from the commencement of legal education, emphasizing the strength and independence of our own laws. And again, I'm not suggesting you throw out the baby with the bathwater. We have benefited greatly from the common law. We continue to do so. The mode of reasoning, stare decisis, structure and system of the law, that's fine. We take the best, but it needs to be imbued with the culture, tradition, and strength of each jurisdiction's identity and needs domestically. Finally, very quickly on cross-border challenges, its implementation and practice is all the rage at the moment. It is an essential component to ensure a smooth mode of interaction between countries as trade, commerce, and other relationships abound between nations, inter se. In view of the reality of sovereignty, the need to organize our relationships in the law so as to expand into sovereign nations or obtain redress from various ventures in foreign states, it becomes crucial. The centralization and harmonization of such laws has long been in existence, but the Global South has been somewhat slow in participating in the creation and regulation of these laws and challenges. As matters stand today, it is essential that cross-border law, if I may put it that way, is given attention and priority. What I mean by that is there should be more alliances that allow for all parts of the world to have their say. The need to ensure that the enforcement of cross-border laws is not concentrated in or monopolized by specific areas geographically is important. The reality is that various nations enjoy different economic status, different conditions, and that all these matters have to go into the mix, so to speak, so as to arrive at solutions which take into account the reality, and that is the playing field is not even. So in terms of education, it is important that there is active participation. This is not only at the level of universities, but even more so within the profession for governments and all the stakeholders to try and achieve an equitable outcome in cross-border matters. And that must be articulated early, quickly. So I think I've covered all my 4 areas. I hope I've stayed within my 10 minutes. Thank you so much for listening so patiently. Thank you.
Thank you, Honorable Justice, to setting the tone for the conference. Moving on, we have 5 panelists, the finest legal minds in the Commonwealth, to make presentations apart from the discussants. And as you know, all these legal luminaries have immensely contributed in reshaping and redefining the justice administration and legal education in the Commonwealth. For the presentations, we have 8 minutes each. I request the speakers either to speak from the podium or from your respective places as you please. To begin with, may I invite Mr. Frank D.R. Ali, Attorney General, Republic of Seychelles.
Thank you, Chair. And all protocols observed. First of all, I'd like to, like everyone else who had spoken before me, to thank the Attorney General of India and the Solicitor General for this commendable initiative. I will get to the meat of the matter. I want to speak this afternoon with regards to the legal education to those who provide legal services, that is, the lawyers itself, but mostly government lawyers, and those who administer the law, and those who use the law. As you all know, as Attorney General and Solicitor General, our role is very diverse. We fly many kites during a day in the life of an Attorney General or a Solicitor General. I don't need to go into greater details of what we do. We all know what we do every day. And we do this based on our mandate. Some of us, our mandate ranges from criminal prosecution, legal provision of legal advice to government, legislative drafting, mutual legal assistance in criminal matters, government transactions. So this wide mandate, or diverse mandate, requires that we perform our function through government lawyers. And in some of the Commonwealth states, you'll have specialized training for the government lawyers, but in many, in particular small islands, small jurisdictions, you won't find institutions that provide such specialized training. Yesterday, our colleague from Uganda spoke about the requirement for the judges to be specialized. And we also should look at our government lawyers specializing in fields that they require that are required, so as to perform their duties. And often they have, as I would say, on the other side, seasoned lawyers in the private practice, in private sector, and they may require this kind or the same kind of training to be able to deal with what transpires. So I have noted, for example, in some countries, especially with where the attorney, I know, for example, in Kenya, where they have a specialized training institute for the prosecutors. So this helps them when they get to work in government, in the Attorney General's office or the Office of the Directorate of Public Prosecution, to understand the rigors of what is required of them and give them the appropriate grounding. we also, earlier, it's been said about how we need some finishing school. And we may also look at how we integrate bar school and pupillage or contract or trading within the law school, within the bar finals. So this is also very important because then you get the required training. You can, a young lawyer will be able to have some sort of internship in both the Attorney General's office as a court researcher and also in the private sector. So it will give the young lawyer more capability when he goes out into the private practice or join government, the Attorney General's office. And I'd like to also speak of legal education for the people. As we often say, we are governed by the rule of law, and if we are to live in accordance with the rule of law, then obviously the law should be easily accessible and freely available to the public. And there is a need to have a continuous legal education for the people in key aspects of the law. Every country, therefore, should encourage and promote legal education for its people. But where there is no legal services authority that provides such legal education, then I believe the Attorney General should come in to fill in that gap. And as was said yesterday, I think, we should educate the public on their legal rights so that advantage is not taken of their ignorance of the law. And often we ask ourselves, are we doing it? And if not, how we do it? And in the past, there had been public consultation when it comes to new legislation. In my country, we often do public consultation. We are about to do one for a new sexual offences bill. But the initial call and objectives of this conference is to seek new methods to resolve emerging issues. And this morning, one of the participants spoke of how we should embrace artificial intelligence. Social media has been around with us for a longer period, and we have embraced it, but how we can embrace it more, how we can use social media, which is what the public uses a lot, to be the forefront of legal education to the greater public, to educate them of their legal rights. In fact, in my office, we have started a discussion of how we would set up a social media channel to educate the public on their legal rights. The central banks, for example, is doing the same on financial education. So we want to do the same. We also need to educate those who administer the law, the public servants. We have organized legal awareness training to accounting officers, chief executive, permanent secretaries, where we explain to them how they will need to administer the law. The Access to Information Act, for example, how they need to prepare legislation, how they go to consultations. So these are how we want them to be able to work better with the laws, and this fosters good governance. So, as Attorney General, I think, and as government lawyer, as we know, we are the center of public administration in every sense of the word, and by this we need to ensure that we foster and ensure sound public administration. Thank you.
Thank you, sir. I invite Mr. Lionel Yee, Deputy Attorney General, Republic of Singapore, to address the gathering.
Well, thank you, Chair and Co-Chair, Honorable Judges, Honorable Attorney General and Solicitor General of India, colleagues of the Commonwealth, law officers, practitioners, teachers, and students of the law. It's a real honor for me to be invited to this gathering, and I want to begin by expressing my heartfelt thanks to the Government of India and the Commonwealth Legal Education Association for the warm hospitality, for the initiative, and for the hard work in organizing this wonderful event. Making future-ready legal education has been the subject of some recent developments in my country, Singapore. A working group was established to review legal education in Singapore, to ensure that our lawyers are equipped with the skills and the knowledge to meet the demands of legal practice, both now and into the future. The group looked at trends, many of which have been discussed over the past 1.5 days, trends affecting the profession, like the proliferation of technology, the globalization of legal practice, and so on. It conducted many consultations and surveys to identify what were the gaps in the current legal education system, and it looked at formal legal education starting from law school all the way through to continuing professional education for lawyers. The working group consisted of the deans of all our law schools, as well as representatives from law firms, in-house counsel, and the government, and reported to a steering committee consisting of the Chief Justice, current and former law ministers, the Minister for Education, and the Attorney General. The report of the working group was published about 4 weeks ago. It is available online on the website of the Singapore Ministry of Law, and in this presentation, I would like to highlight some of the more significant recommendations in that report. But let me state at the outset that the report addresses the future of legal education in Singapore, and so therefore its recommendations apply in the context of Singapore. I will start with the recommendations relating to formal legal education, and here the focus is on the skills and the knowledge required to begin a career in the legal profession. So let me highlight 4 significant recommendations. First, the so-called priestly 11 subjects will remain the core law subjects for the law schools, and these are administrative law, civil dispute resolution, company law, contract criminal law, ethics and professional responsibility, equity and trust, evidence, constitutional law, property, and torts. But what will be added is a new compulsory component of civil law. Although Singapore is a common law country, many jurisdictions in our region are civil law countries, and we have substantial trade and investment links with China, with Indonesia, with Vietnam, and other civil law jurisdictions. Multinational businesses and family businesses based in Singapore often have to deal with cross-border issues. Even family law practitioners may encounter civil law issues, such as when matrimonial assets are located in another jurisdiction. Now, our lawyers do not need to be experts in Chinese or Vietnamese or Indonesian law, but they must have some basic knowledge of civil law systems, the law of obligations, the law of property, the law of business organizations, so that when foreign law issues arise, they are able to instruct and work with local lawyers in those jurisdictions to provide good advice to their clients. Secondly, and as has been repeatedly emphasized in this conference, ethics and professional conduct need to be part of the values of the legal profession and must be instilled and reinforced from entry into law school all the way throughout a lawyer's career. The working group therefore recommended not just including ethics and professional responsibility in the curricula of the law schools, as well as the qualifying process for admission to the bar, but also requiring that all lawyers, regardless of seniority, must take modules on ethics and professional responsibility as part of their continuing legal education. Third, knowledge of the law alone does not make a law graduate ready for the practice of law. The working group therefore recommended that the curricula of law schools must also include, first, communication skills, second, technology and data literacy, and third, accounting and financial concepts. And let me speak briefly on each of these. On communication skills, law students must understand that the context matters, and for example, how one writes a legal submission to the court differs from a written legal advice to a client who is not legally trained. And so the quality of writing will be part of the assessment rubric for law school examinations and term papers. On technology and data literacy, the focus will be on providing law students with baseline familiarity with legal issues that arise from technology, and also with the ability to use legal technology and data analytical methods and tools. And finally, on accounting and financial concepts, Singapore is a business and financial hub. So some knowledge of accounting and financial concepts like balance sheets and profit and loss statements is therefore essential for any Singapore lawyer. Disputes lawyers must, for example, understand how to use financial and numerical data to make effective legal arguments and cross-examine witnesses. And even family lawyers will often have to grapple with financial statements in the identification and division of matrimonial assets. Finally, the working group recommended that legal internships of at least 2 weeks must be made compulsory for all Singapore law school students. And that is to ensure that students understand how what they learn in school translates into real-world lawyering. Then turning to the working group's recommendations on continuing legal education, I will just highlight one. The working group recommended that continuing professional development requirements for lawyers so that all lawyers, regardless of seniority, must clock 16 training hours every year. At present, while junior lawyers are required to clock 16 training hours, the most senior lawyers only need to clock 4 hours. And there is no reason why there should be this differentiated regime. Learning is lifelong, and all legal professionals must keep their knowledge and their skills updated. I'm going to conclude. For Singapore, legal education doesn't stop upon graduation with a law degree. Society and lawyering will change in the course of one's legal career. Legal education has to be a continuing pursuit throughout that career, and we need to approach it in a holistic manner with different parts of that education system doing their part in a complementary manner. So thank you very much for your attention.
Thank you. I invite Mr. Thabo Chakaka Nirenda, Attorney General, Republic of Malawi, to enlighten the audience.
So all protocols observed. I think my speech was heavily edited. I don't know whether it fits the topic of the session today. I'll try to fit it. Let me start by introducing myself. I think it has not been, my name has not been pronounced properly. My name is Thabo Chakaka Nirenda. I'm I think the youngest Attorney General on this earth. I could try to align if my memory or my research serves me right. So the people of Malawi, the warm heart of Africa, are sending their special greetings to you all. Malawi is a country endowed with peace, tranquility, wildlife, and natural beauty. Chief amongst them, the Lake Malawi, being the third largest freshwater lake in Africa, and the fifth largest freshwater lake in the world. I call upon you all to visit such a beautiful country someday and feel the love of the Malawian people. The landscape of legal affairs is evolving every other day, such that we must explore avenues of addressing the cross-border issues that impact our justice system. We can do that by continuous legal education. It is out of such shared challenges and opportunities that we should want to acknowledge the importance of collaborative efforts in addressing those issues, as I highlighted, and that should be through continuous legal education, and I think that's what we are doing now. Remember, everything that hinges on the law has a bearing on development, which is defined as a progressive transformation of the economy and society. In one of his lectures, Adam Smith observed that the imperfection of the law and the uncertainty in its application was a factor that retarded commerce. Therefore, the Attorney General, the education institutions, or the Solicitor Generals are key in achieving development goals. For example, the Attorney General is responsible for such other important matters as policy making, legislative drafting, sitting as an official member in a wide area of forums, and oversight responsibilities over the functioning of the overall legal framework of the country. And most countries, the Attorney General sits as also the chair of legal education. In this regard, the Attorney General, who is responsible for the framing of quality laws and their implementation, must be lauded when the development is achieved in a country. She or he must be thwarted when a country is underdeveloped. This is because poorly designed, poorly framed institutions, and poorly implemented laws, and poorly trained lawyers depress the chance for economic vitality. So for the purposes of development, there's a need to formulate laws with better regulatory design, secure strong regulatory compliance, and have governments implementing them more effectively, leading to economic and social development. There is also need for political will and the rule of law. And also, as I said, there is also need for robust training for all lawyers and judges. Moreover, the law may not be effective in the absence of a suitable legal framework and effective institutional arrangement. And those institutions include law schools. Further, a law may not be effective if it's not adaptable to socio-economic conditions. Additionally, the impact of the law cannot be assessed separately from relevant institutions. The enactment of anti-corruption laws, financial laws, procurement and regulators laws will be ineffective if the essential institutions that enforce them are absent. Moreover, judicial decisions are also expected to promote particular policies. I'll come back to that, but let me say that as legal practitioners representing various jurisdictions within the Commonwealth, we are confronted with myriad of complex and interconnected challenges that transcend national boundaries. Some of the most challenging we face are the growing prevalence of transnational crime, which includes money laundering, illicit financial outflows, cybercrime, human trafficking, climate change, international investment and trade, terrorism, and human rights violations, just to name a few. This call for cooperation in extradition, mutual legal assistance, and information sharing as essential instruments for effective law enforcement and prosecution to combat such common threats. I wish I had enough time to expand on each of these challenges, but let me proceed and see how I can do. In addressing cross-border challenges, and also the importance of legal education, of transforming legal education, it is imperative that we seriously and honestly discuss strategies with which to promote access to justice, defend human rights, and ensure the fair and impartial administration of justice across the Commonwealth. Just as one scholar analyzed Mahatma Gandhi's idea of legal justice and summarized this, Gandhi's instance of truth is not a matter of personal conviction. It is a matter which is inherent in the proper function of the law and society, and above all, in the proper dispensation of legal justice. In Gandhi's definition, justice is an inquiry into truth by using fair means as to what is due to whom and who is entitled to what within the established framework, when the framework itself is not faulty or discriminatory. In addressing contemporary legal challenges, there is need to encourage the exchange of best practices and knowledge sharing amongst attorney generals, solicitor generals, the academia, and legal players. My strong conviction is that we should adopt alternative dispute resolution mechanisms, ADR, such as mediation, arbitration, conciliation, and negotiations. By training lawyers in ADR, lawyers will be in a position to advise their clients not always to pursue legal action through courts, because that takes time and drains resources. Court battles also scare away investors, and delay development. I know most Commonwealth countries signed and ratified the Convention on the Recognition and Enforcement of Foreign Arbitral Awards and have domesticated initial rules. This is a way we would achieve harmonization of legislative drafting, and we can carry it forward by also training the new generation about these new emerging issues and agreements. Ladies and gentlemen, laws are made in such a manner that they meet the needs of society, and the needs are reflected in values and aspirations which may differ from society to society. Notwithstanding the variations, some common problems need a common approach and a common solutions through the harmonization of laws across jurisdictions. The common law, as both a type of law and legal system, can be viewed as a form of harmonized law for Commonwealth countries. However, harmonization of laws would be futile if there were inconsistencies in their interpretation. This therefore calls for harmonized rules of statutory interpretation, training, and of course judgments that achieve unified approach in the implementation of these laws, and also consistency. Harmonization of laws must not be done for the sake of it. The idea of harmonization of legislative systems in the Commonwealth jurisdictions has to be linked with the respective visions and aspirations, which are mostly drawn from and aligned with UN Agenda 2030. In respect of African countries, further customized aspirations are documented in the AU Agenda 2063. Their implementation depends on the quality of the laws and the capacity of the states to implement the law. Harmonization can also extend to other areas such as trade in the following: elimination of regulatory inconsistencies. Additional time. Okay. Harmonization may help to eliminate conflicting and contradictory regulations that can create confusion and inefficiencies for businesses and individuals operating in multiple jurisdictions, facilitating trade and investment, promote consumer protection, and to achieve this, I'm suggesting cooperation and coordinations amongst government, and also I'm suggesting international agreements, the domestication and ratifications, also suggesting model laws and standards, and regional interpretation. Number 5, the signing of mutual legal assistance agreements and training on them. In my speech at a UN event in Abu Dhabi, UAE, I said it is imperative that extradition treaties, mutual legal assistance agreements in criminal matters and mutual legal assistance agreements in civil matters are negotiated and signed by countries that are vulnerable to wildlife crimes. These agreements are as the Prime Minister of India, His Excellency Modi, told us yesterday, would help to achieve justice in other countries. Distinguished ladies and gentlemen, as I said, legislation is a formal expression of policy and follows that before the legislation can be drafted, the policy sought to be implemented by it must be determined. We live in a global village in which there is constant interaction in avenues of trade, diplomacy, security, and other social and economic areas incidental to human development. Just being the driving force of social and economic development, attorney generals within the Commonwealth can play a significant role in bringing about harmony in the legislative drafting across jurisdictions. For instance, to attract investment, Malawi only signed BITs with 7 countries. And may I suggest that Commonwealth countries should also sign amongst themselves BITs. And this will also achieve, actually, harmonization of legislative drafting. As I conclude, let me urge all of us to embrace this opportunity to engage in meaningful direct exchange best practices and forge stronger ties in our collective pursuit of effective cross-border justice delivery. Together, we can navigate the complexities of our interconnected legal landscape and ensure that justice knows no borders within the Commonwealth. I want to take time to thank the Office of the Attorney General and Solicitor General of India, the Ministry of Law and Justice, and Claire for organizing this conference in such a wonderful fashion. The Indian government has also given us such world-class hospitality in this city of Delhi. I'm loving it here. I will talk to the organizers to offer me extra days after the conference is over so that I fully appreciate the beauty and warmth of the great country India is. I want to tap wisdom from the great men and women of this great nation, a nation that gave birth to one great lawyer, Mahatma Gandhi, who left huge mark on the earth stock. Once again, thank you for your attention, and may God bless you.
Thank you. I'm happy to inform you that live streaming of this session is going on. So when foreign delegates make their presentation, the people from your respective countries may watch it on YouTube. May I invite Professor Dr. A. Kumaralingam, Professor of Law, National University, Singapore, also representing CLIA Southeast Asia, to share your thoughts.
The Honorable Attorney General, Honorable Judges, distinguished delegates, distinguished students who have taken an oath of silence for the next 8 minutes. I want to begin by echoing my Deputy Attorney General and thank the Government of India for giving us such a warm welcome and wonderful hospitality. On a personal note, I also want to thank India for giving me the love of my life, my wife, who is from this very city, where we got married 24 years ago, so it's always good to be back. Thank you. So I'd like to begin my presentation with a cautionary approach to the reform of legal education, before I then propose a more ambitious project for the future of legal education. Law schools, and I represent the law schools here as an academic, have many stakeholders and multiple missions. They are academic institutions committed to the goals of higher learning, but they are also professional schools committed to the training of legal practitioners. It is critical to balance the academic and the professional dimensions of legal education. Students need to be equipped with the necessary skills to practice law in a fast-evolving world, but at the same time, they must also have a critical mind that is able to question and to challenge conventional wisdom. Law schools must develop and nurture close relationships with the government, especially the judicial and executive arms, and also forge close ties with the legal profession. Yet at the same time, law schools must remain independent in charting the course of legal education and championing academic freedom. Institutes of higher education have three main functions: research, teaching, and service. The history of the institutions of higher learning shows that these functions ebb and flow. Centuries ago, the emphasis was on moral and religious guidance or teaching of students. During nation-building periods, which we see in developing countries now, the emphasis then shifts to pressing universities and institutes of higher learning to go into technical and applied research to help build infrastructure and develop the economy. More recently, since the mid-20th century, governments and the private sector, recognizing the huge intellectual capital in universities, have poured funding to encourage pure research, to produce innovators who can solve major problems. The educational mission of universities thus adjusts to these shifts in priorities, preparing the workforce of the future, creating innovators and entrepreneurs, producing thought leaders who can challenge conventional wisdom. But these missions can also be contradictory. The workforce needs to be work ready and hit the ground running, follow the rules. The innovators are disruptors. They are there to reject conventional ideas, to find new solutions. Thought leaders are big picture individuals who look at the longer horizon and not the immediate needs of the day. Now, universities clearly have a responsibility to help meet the needs of the day, but the needs of the day are dynamic. And when different stakeholders are involved, universities may be pulled in different directions. This is especially so for law schools, which serve several masters, including the central university leadership, the government, and the legal profession. It is vital that law schools are proactive in engaging with all of these stakeholders to think about legal education and reform. Now, that's my cautionary tale. Now, here's the ambitious part. There are some enduring themes in modern legal education which will continue to be relevant in the future, and they include interdisciplinary education, comparative education, experiential learning, skills-based learning. These perspectives and skills are crucial to developing and molding the lawyers of today and the future. But that is already done to some extent at some law school and perhaps needs to be done more. I'm going to focus on one area of legal education which resonates with the key theme of this conference, legal pluralism, which includes cross-border justice and transnationalism. Now, in my view, contemporary legal education must include transnational, regional, and international experience as well as civil law exposure for Commonwealth students. Because when transactions cross borders, lawyers need to grapple with the law and the culture of the foreign state. Singapore, as the Deputy Attorney General has said, is a common law jurisdiction, but our law firms are involved in lots of cross-border transactions with civil law jurisdictions. Our students thus need to have some understanding of civil law. Now, it is important to do this at the structural and institutional level. Thus, beyond incorporating civil law in our curriculum, we should also enhance regional cooperation at the institutional level so schools can learn from each other. Now, this can have significant educational and economic implications. So South Asia has shown leadership with the establishment of the South Asian University in 2010, which is supported by 8 SAARC member states. It has a Faculty of Legal Studies. In ASEAN, in 1995, the ASEAN University Network was established to connect universities in the 10 ASEAN states. And recently, the ASEAN India University Network was established at Nalanda University to encourage greater collaboration. It doesn't have a law department or legal studies department. But I think a regional legal education institution could facilitate comparative legal education and training and contribute to harmonization of laws within a region. Now, at my law school at NUS, we have several initiatives, including the Asian Law Institute, the Asian Society for International Law, the Asian Law Schools Association, and so on. But these institutions are focused on research and networking, not so much in terms of legal education. Having a concrete structure with a strategy on transnational legal education and training could have benefits for all of us. Now, ASEAN and SAARC already have close ties. CLAA could play a coordinating role to establish such a legal institution. To give an example, there's a Center for Transnational Legal Studies in London, which NUS is part of. But they focused on the academic aspects of comparative law. We can try and focus on practical aspects of transnational law by trying to establish an institute within Asia. This would also address some of the key points made by Justice Padmanathan in her speech when she alluded to the need for an Asian voice on transnational matters. So this is something that I think we should be thinking about in terms of developing legal education. The students can participate in this institution without having physically to go there, because today all of us are so comfortable using remote learning. The COVID-19 pandemic was a horror, but it did bring about some positive changes, one of which is the interconnectivity. So it's so easy now for us to launch courses and have students from across the world joining in, and it is just as effective as having them in the classroom. So if we were to develop some sort of a cross-border institution, we could encourage students, practitioners to come in, to think tank, and maybe to acquire, if it's an undergraduate student, over the course of the 3 or 4 year LLB, to acquire sufficient modules in different areas of civil law and Asian law in a structured manner, and then receive a kind of certificate in transnational legal practice at the end of the day. We have to accept that we live in a world of legal pluralism, and we have to embrace this legal pluralism when we think about the future of legal education. Thank you.
Thank you, sir. May I invite Dr. Sudhir Krishnaswamy, Vice Chancellor, National Law School of India, University, Bangalore, to enlighten the gathering.
Good morning, and thank you for the invitation to be present at this panel today. The Attorney General, Venkat Ramani, and Professor Shivakumar at the Indian Law Institute took tremendous efforts to get us here. Thank you, sir, for staging this conference and then for having us here. Honorable Justice Nagaratna, Justice Prashant Kumar Mishra, and Justice Nalini Padmanathan for anchoring this session, and Vikramjit Banerjee, a good friend and alumnus of the National Law School, for welcoming us here as we start this session this afternoon. There are many other distinguished members on the dais and in the audience, and precious students sparing their Sunday with us. I can understand the chatter. It's not the most engaging topics for a diverse and large student body sitting at the back there. Thank you for your patience. So I address you today both as the Vice Chancellor of the National Law School of India, Bangalore, as well as the Secretary and Treasurer of the Consortium of the National Law Universities, which is a 22-member consortium of national law universities spread across the breadth of the country. I'd like to begin with a very brief reflection on the state of legal education in India. I'm sure that all members present here are reflecting on a possibility of a Commonwealth legal education, drawing on their national experiences, and the Indian academics and scholars here will do no different. But I think a very brief summary might be useful. So India has had the advantage of having institutionalized legal education as early as 1855, very early institutionalization. And the institutionalization was in university departments. So this is important because in many other jurisdictions, the institutionalization of legal education took place in the Inns of Court, as in England, and in other trade and guild schools. So in India, the institutionalization took place in university departments, so nested firmly within academia and with a commitment to both the rigors and processes of academic work. So that early institutionalization spawned university departments in law all around the country. And even today, the dominant model of the delivery of legal education in India is through the university department. In 1961, the Advocates Act conferred on the legal profession a statutory power to both regulate legal education and determine, in some standard-setting sense, the curriculum in legal education. Now, this step in 1961 tethered professional legal education and academic legal education. Those looking even at the United Kingdom today would recognize that the tensions between the professional requirements of legal education and the academic requirements of legal education are alive in the UK today. And for reasons of the 1961 Act, they're less present in India. So the Bar Council has a role in legal education. There are often some disputes about precisely where that role begins and ends, but with those skirmishes on the side, the Bar Council and legal education are firmly tethered. In 1985, but more precisely in 1988, we created the National Law School in Bangalore and the National Law Universities to follow. The National Law Schools did something quite different in Indian legal education because they produced for the first time and at scale world-class legal education in India. Now, 3 decades on from the 1980s, at least the top universities in the country produce legal scholars comparable with the best in the world. They compete for positions across the world in academic, professional, and government settings with the best in the world. There's almost no difference between the graduates from the top law schools and anywhere else in the world. Now, we couldn't say this in the 1980s. We can say this in 2024 with a lot of confidence. In the last 3 decades, that's the last 3 decades since the creation of the National Law School, 3 dominant themes emerge. First, the rapid expansion of legal education. The number of legal education providers in India has tripled. The number of students aspiring for a legal education has gone up probably tenfold, though there's no accurate estimate of it. We've also seen the proliferation of a public and private sector delivery of legal education at scale. With this, digitization and internationalization of legal education is increasingly taking place. The embrace of digitization across legal education in India is extremely strong. And it's no surprise that with the courts making the digital turn, young legal advocates are ready for this. Internationalization, by contrast, is still in its early stages. And there is a lot of potential for that in the near future. And I guess a conference like this puts that into context. So that brief about legal education in India is useful as a preface to what I'm going to say about what a Commonwealth legal education can be about. We understand, I trust that all those in this audience understand that the idea of the Commonwealth sprung from the embers of a dying empire. That is a historical truth. And it's also clear that from the audience and the people in this auditorium, that we don't see the Commonwealth as a euphemism for or some kind of apology for continuing with the residues of empire. So I think that we're very clear about. That's not what the Commonwealth is about. It's post-colonial in its form, and at least after India and Pakistan initially joined the Commonwealth, it has become post-colonial in majority in terms of the membership. But I think the conversation that is occurring across the Commonwealth today is about what it means to decolonize, or what does it mean what is decolonization got to do with the project of legal systems? And I'm going to address this squarely. I haven't heard, I take it that our keynote address, Justice Nalli Padmanathan spoke about this briefly, but I'm going to be far more square on the question. The decolonization question is common in many of the Commonwealth jurisdictions. For those of us who study and read these systems, we know that this is an important issue. It's also an important issue in India today. In one version of the argument, what we really need to do is to indigenize the Indian legal system and indigenize all Commonwealth legal systems. A similar pressure is felt. I think that a common assumption that all of us may share is that the hegemony of the English legal system or the English court system is no longer acceptable. This, as a decolonizing move, is a sort of a given standard common, maybe that an issue settled at least 3 decades ago, but maybe some facets of it still remain. But if decolonizing means at the other end a complete indigenization of legal systems, then I suspect that this kind of gathering may not be possible 10 years later if that project is extremely successful. So I think it's useful for us to reflect on an occasion like this to ask what is it between a post-colonial shift, which we acknowledge, and a decolonizing move, which we're relatively unsure what that means. And I'm going to suggest something here and draw on 2 experiences before I conclude. If decolonization means something, it means that we become much more attentive to the structures of power and not obsess about the nature of the discourse, that is the form and discourse. We are interested in geopolitics, we are interested in the politics of our domestic nations, the relationship between state and society. We're concerned about these power relations, and we have some ethical commitments here about the outcomes we want to achieve. But we are not committed to a peculiar form of indigenization, which means that we abandon all versions of the English common law system. So it's this model or this approach to decolonization that might have great meaning for a gathering like this and for a project of common legal education. I take inspiration from 2 examples, and I'll do this quickly, and I'll spare a reminder for the work. And let me do the first. The National Law School, established in 1988, engaged in an elaborate approach to admitting foreign students in South Asia and across parts of Asia and Africa, more than 20 countries. Today, our alumni sit on the Supreme Courts of many of these countries. They are senior lawyers and academics across the global South. And in this, we notice a form of movement of students, faculty, and ideas that is unmediated by the global core. The old language of colonialism, the pole, the metropole, and the edges. All of this happens on the edges of old empire. And this is a very successful model for a Commonwealth legal education to aspire to. My second example draws on another initiative with which my university was closely involved, which are the Bangalore Principles of Judicial Conduct. The Bangalore Principles of Judicial Conduct, which were framed in the late 80s, began in the late 80s, but finally framed at the turn of the century, is a soft law model on judicial conduct which emphasizes independence, impartiality, integrity, and so on. I won't go into the details before I get another reminder. And what it does, what's interesting about the Bangalore Principles is that it emerged from the South, it was built on partnerships from the global South, and the principles confirm values that are shared across the Commonwealth. The rule of law, constitutionalism, democracy. What both of these examples show me, and I hope convince some of you, is that this other model of decolonization is possible, it's relevant, and the transformation of legal education that embraces shared values across the Commonwealth, but doesn't press too hard on a very sharp kind of particularism, is the way that we might want to focus and shape the discussions going forward. Thank you.
Thank you, sir. Now discussants will address the gathering. As per the program schedule, each discussion has 3 minutes. I respectfully request all of you to adhere to the timing as we have to also arrange round table immediately after the lunch. May I request Ms. Daphne Hong, Solicitor General, Republic of Singapore, to address the gathering.
Thank you. I joined my Deputy Attorney General in extending my thanks to our friends from India for the warm hospitality that you have extended to me and for the privilege of addressing you. Since my Deputy Attorney General has shared on the review of legal education for all lawyers in Singapore going forward, I thought I should use my 3 minutes to share some perspectives from the angle of continuing legal education for government lawyers. When I first started out in the Attorney General's chambers, a mentor was appointed to guide me in my first 6 months. After that, I was pretty much on my own. Learning was largely OJT, or on-the-job training. I was assigned legal files and cases to work on, and I either sink or swim. That was 17 years ago. Fast forward today, we find ourselves in a situation where legal work has gotten much more complex and cross-cutting. Deadlines for delivery of legal work has gotten much more demanding. How many of you here have the experience of asking our government officials, when would you like the advice? And them saying, yesterday. So things have moved very, very much faster. Social media is in overdrive, and we find our work being subject to the scrutiny of the court of public opinion. All these add up to a need to develop government lawyers in a structured and systematic way in order to not just fulfill the potential of our lawyers, but also to equip them to handle the demands of the job. So how did we go about this? We first set up the Attorney General's Chambers Academy about 5 years ago to take charge of all training activities in AGC. It drew up competency frameworks and very detailed training roadmaps for all lawyers and implemented them. So for instance, the roadmap will say in the first 3 years, what sort of training programs is required, what are the foundational programs, for example, covering advice writing, basic advocacy. In the next 3 years, what are the advanced programs that our lawyers must be put through, including more advanced advocacy programs. Our lawyers are also sent for leadership programs, etc. Our best lawyers are sent for master's or PhD training. We also release our officers. We give them time off to go to the universities to research and to publish. So what is emphasized is lifelong learning. Our academy organizes regular lunchtime talks. So hopefully with this, we have a target of 16 hours. We actually monitor this target. And if our lawyers do not meet 16 hours of training, we give them a gentle nudge. And most recently, we have increased the mandate of the academy to cover training not just for AGC lawyers, but for all government lawyers. This stems from the realization that when it comes to members of the public, whether legal advice is given by AGC lawyers or government lawyers housed in ministries, to them it is all the same. Whether the rule of law is given practical expression and whether it is achieved, to them, whether you are AGC or lawyers, it doesn't matter. So now the AGC Academy also trains government lawyers outside AGC. So with this, we hope that we can imbue our all government lawyers with at least a basic set of legal knowledge for them to discharge their responsibilities and hopefully administer justice and give real meaning to access to justice as well as justice. My time is up. Thank you for your attention.
Thank you. I request Professor Dr. Masum Billah, Dean of Law, Jagannath University, Republic of Bangladesh, to address.
I am running because time is also running. First of all, give me a round of applause so that I can speak properly. It is conventional for me to fall asleep when I remain at the audience side, but I was there, so I remain very cautious that I don't feel asleep. Now I have written something in my own hand, but by now it has become inaccessible. I cannot understand my own handwriting. In fact, that has been the problem with law and legal studies. It is very complex. You cannot enter into the language of the law, into the realm of the law. Now, people fear about their creation, but there is also an ecstasy of creation, ecstasy of joy, as fondly has been termed by our national poet, Qazi Nazrul Islam. I note that the Honorable Attorney General is also a very good poet. So we have this joy of creation, of creating our own motherland, which we fondly call Bangladesh, back in 1971 under the leadership of Bangabandhu Sheikh Mujibur Rahman. Now, Bangladesh and India are ever-tested good friends. They're our good neighbors. It is said that you can change your wife, but you cannot change your neighbor. Right? Now, Tagore has tied us together with Amar Sonar Bangla on the one hand and Jana Gana Mana on the other hand. So we have this jurisprudence of patriotic emotion. Thank you very much. Now again, deep at the root of our birth, there is this proclamation of independence, where India has also intellectually contributed. Subrata Ray Chaudhary, the noted jurist, wrote the Genesis of Bangladesh, where we have fondly written that we have declared independence in order to establish social justice, equality, and human dignity. Right? That I can relate with the teachings of living legend of the Commonwealth, N.R. Madhava Menon, right, who said that the purpose of legal education will fail if we fail to establish human dignity. So, each and every law school should aim that perspective. And also I recall the famous Indian legal mind, Upendra Bakshi, who said that the gap between rich and poor will not evaporate until the legal activists will emerge. Right? So we need to bridge up these gaps between this poor and rich. Now our law school has become stagnant. So we are speaking about transformation. And the law schools in many ways disappoints the law students. They will sing that, give me some sunshine, give me some rain, give me another chance so that we can grow up once again. Right? So the other day I heard Venkaiah Naiduji, who said that there are three forms of government. One is reform, perform, and transform. So we need to reform first, then we need to perform, and we need to transform. So I have got the chirkut, that time excluded. So being the baby dean, I plead 1 more minute to finish it properly. So thing is that we are talking about collaboration, but we are not giving elaboration of it. We are talking about motion, but we are excluding emotion. We are becoming voluminous, but we are not becoming luminous. So therefore we need to be luminous, and we need to borrow of the idea of migration of constitutional ideas, human rights ideas, and many more. So let us together create a we jurisprudence instead of I jurisprudence. Thank you so very much. Jai Bangla, Jai Bangabandhu.
Thank you, Professor, for that highly spirited intervention, which was equally enlightening and entertaining. To sustain the spirit and vibe of the audience, may I request Professor Dr. C. Rajkumar, Vice Chancellor, OP Jindal Global University, Haryana, to address the gathering.
Thank you. Well, that's a hard act to follow, but I'll try. Thank you so much for giving me this opportunity, the distinguished learned Attorney General of India, the Solicitor General, and also Professor Shivakumar. I am conscious that I am the 75th speaker since yesterday, and we have another 20 more to go, and I have approximately 180 seconds to talk about legal education. I will make an effort. But before I do that, I just want to quickly say that the best part of this kind of a conversation is that it kind of brings together the problems that we are all together facing. And Commonwealth is one such opportunity where we are sharing our joint efforts in addressing some of these issues. So to that extent, I want to congratulate the Attorney General and the Solicitor General's office to conceive this conference and bring all of us together. All right, let me begin by an amazing story. I'm sure some of you know Oliver Wendell Holmes, one of the longest serving judges of the US Supreme Court. He was sitting on a train in Washington, D.C. on a winter morning, and he was already 91. He was a very senior man, and quite remarkably, there was a ticket collector who was, passing through different people in the compartment. And when he saw this ticket collector coming towards him, Justice Holmes was frantically trying to locate his ticket. And he was searching everywhere and he couldn't find it. And he was anxious about it. And then finally the ticket collector landed up at Justice Holmes' seat. And then there was a moment, and of course the ticket collector was conscious that he was searching. So he immediately said, "Oh, you know what? We know you, Justice Holmes. You are such a distinguished man, and I'm sure you have the ticket. Don't worry, it's okay." And then in response, Justice Holmes said, "No, young man, that's not the problem. I need to find the ticket, not to give it to you, but I need to know where I am going." The reason this story is important is that our situation, especially the students and the stakeholders in legal education, is that you are all like the ticket collector. You all trust the legal education phenomenon to somehow solve and address the big problems. And we are all like Justice Holmes, trying to figure out where are we going in terms of our direction. So quickly, I want to say that the first and major challenge that we are facing in legal education is that we have not been able to develop an academic imagination for law schools. Even today, the law schools have been focused far too much on the professional approach towards legal education, where the only outcome for legal education happens to be a lawyer or a judge. This professional-oriented approach towards legal education has unfortunately resulted in a huge sense of mediocre approach towards education, whereby we have institutionalized mediocrity across law schools. I can speak about India, but the story is not very different, at least in most parts of the developing world, including in South Asia. The second major challenge we are facing is that law schools have not been conceived to be research institutions. They have not been supporting the idea of transformative legal education, whereby we can work in the realm of ideas and in that process engage in legal reforms and in many ways advance the cause of jurisprudence. This has become a major challenge, whereby even our judges are not able to rely upon the work, the research, the scholarship that ought to emerge out of our law schools. Third, at least in the Indian context, I must say, and with all due apologies to many of my friends here, we are indeed facing a huge crisis. We have approximately 1,750 law schools in India, and of which approximately 28 of them are national law schools. Most legal reforms today have had a national law school focused approach towards legal education. We need to move beyond it. The national law schools produce approximately 2,700 graduates, which constitute less than 2% of Indian law graduates. Unless and until we focus on the wider imagination of Indian legal education, including in the state public institutions where there are law colleges, and across India there are numerous law colleges which needs and cries for reform, and unless we focus on them, we simply won't be able to achieve that objective. The fourth is that we have not been able to develop an interdisciplinary approach towards legal education. The significant challenge and the adverse impact that has resulted in the 5-year program being the gold standard for legal education is that we have not been able to provide foundations for legal education which ought to be drawn from other disciplines, including political science, history, anthropology, sociology, philosophy, literature, economics, and a range of other disciplines. Most students in 5-year law schools, unfortunately, are looking at social sciences and humanities as a distraction where they have to ultimately get into law, and that approach has impacted adversely the future imagination of both the bar and the bench. We really need serious introspection as to how we can reimagine it. In 2019, I wrote an article exhorting the national law schools in particular to start 3-year LLB programs. And I'm delighted to note that both the National Law School in Bangalore as well as Nalsar has started 3-year LLB programs. And we really need to build on that capacity whereby graduates from other disciplines are brought into our law schools. Lastly, I do want to believe that the existing paradigm of marking private law colleges separate from public institutions need to be given way. I had the privilege to study in 4 law schools: Delhi University, Oxford University, Harvard Law School, and University of Hong Kong. And I can tell you that this whole public-private divide that we in India celebrate needs to be broken. Harvard Law School is a private institution. Yale, Stanford, Columbia, all of them are private. And Oxford and Cambridge are public. But the idea of public-private divide needs to be broken. I want to end by saying that we cannot self-congratulate ourselves for the state of legal education we have in the Commonwealth, unless and until we are able to attract the finest students from around the world seeking educational opportunities in our countries. If you look at the growth and movement of students across the world, it has been always from the Commonwealth to the West, including to UK, Australia, United States, Western Europe, Canada, and of course, New Zealand, and not the other way around. Till such time, we are able to attract the finest students from most parts of the Western world to come into Commonwealth countries and to pursue legal education here. We cannot, celebrate the fact that we have reached where we want to. So with those words, I want to once again thank the Attorney General and the Solicitor General for this opportunity.
Sir, thank you, sir, for that powerful and resourceful suggestions, wherein you have given concrete and practical ways to reform the legal education. The presentations and discussions are over. Before I invite the Honorable Co-Chair to sum up the session, with the kind permission of the Honorable Chair, I invite Ms. Hawa Abubakar, Attorney General, Borno State, Nigeria, for a quick intervention.
The Honorable Attorney General of India, other Attorneys General present here, the Solicitor General, the judges. I was given just 2 minutes, so I don't know how I'm going to manage this, but I'll try. Most of the discussions here are very important for us to take it back home. 2 things I want to mention. And this topic vividly reminds me of a professional development program that I attended towards the end of last year, which is leading the law firm of the future. And this is a strong statement that the legal profession is evolving. Law itself is dynamic and it evolves with time. I'm so happy that the presenters here were able to raise issues of restructuring curriculums in law schools and even at the undergraduate levels. And that's the only way we could have what we need in the present time. This is the only way we could transform. This is the only way we could live up to the phase. The world is changing in a very fast pace. And secondly, I want to talk about the technology I was so pleased earlier today when one of the presenters intimated us to accept or come to terms with using or allowing our children, allowing students to come to terms with the use of technology, and especially the artificial intelligence. There is no doubt that it has come to stay, and we have to find a way of how to work in compliance with regulations, I believe. Thank you so much. I don't want to take much of time. It is a huge privilege for me to be amongst the attorneys general, the professors, the judges. Like earlier mentioned by my colleague, the Attorney General of Nasarawa State, Nigeria and India, we've adopted a lot of the criminal procedures here. Our penal code, which is largely in practice in the northern part of Nigeria, is mainly, we adopted it from India, Pakistan, I guess. So thank you so very much.
Thank you, ma'am. May I invite one more speaker, Mr. Alfred Yeboto, Deputy Attorney General, Republic of Ghana.
My Lord Chair, permit me to stand on existing protocols. I have 2 minutes to speak, but I need to let you know much about Ghana within 2 minutes. Let me also, on behalf of the delegation, express our appreciation to the people of India for welcoming in such a good way. The city of Delhi is such a beautiful city. And if you look at the ambience within this, it shows that India is indeed on top of whatever that it does. Now, the case of Ghana. Ghana, since 1958, that it had the first law school, was able to produce not more than 1,000 lawyers until 2004. I was called to the bar in 2002, 22 years ago. At the time that I was called to the bar, not more than 100 students were called to the bar. As I speak now, at the last call to the bar, over 1,000 students were called to the bar in Ghana. So in Ghana, when it comes to legal education, we have 3 main things that we do. 1 is about access. 2, regulation. Then 3, we're also looking at the content. When it comes to access, from 2002 up to date, we've had public university running law increasing from 1 up to 6. Private university from 0 to 15. So as we speak, a lot of universities in Ghana are running law programs. When it comes to the content, I can tell you for a fact that Ghana believes that everything in this world is possible. If you take consolation in the writings of Richard Susskind, when he stated that the future of law will be neither Grisham nor Rampur. Virtual courts, diagnostic expert system, computerization, alternative sourcing global legal services, web-based simulated practice, and much more will be the order of the day. Being mindful of this and being mindful of the fact that Ghana is a land of possibilities. We've imbibed these things and even increased the kind of content that we have in our legal education. Ghana is always ready to receive you as a gateway to Africa, and I invite you to Ghana in December, where we have December to remember. When you come to Ghana, you enjoy our ambience. Thank you very much, and God bless you.
Thank you. May now request Honorable Mr. Justice Prashant Kumar Mishra, Judge Supreme Court of India, to conclude the session and give your comments and remarks.
Honorable Ms. Justice B.V. Nagaratna, Judge Supreme Court of India, and other dignitaries on the dais, learned Attorney General and his team of young and old ESGs, a perfect blending, Advocate Generals from different states, other dignitaries from different countries. Please excuse me for not mentioning the name of all of them, because I know it is very difficult to engage the audience just before the lunch and immediately after the lunch. In this Commonwealth Attorney and Solicitor General's Conference 2024 on cross-border challenges in justice delivery, organized by the Government of India and the Office of Attorney General and Solicitor General and Commonwealth Legal Education Association, we are nearer to drawing the curtains. And this technical session was the most enlightening session. And we have found ourselves at the crossroads of a transformative journey in legal education. Our deliberations have not merely scratched the surface, they have delved into the very essence of reshaping how we nurture the legal minds of future. In recent years, the discourse surrounding legal education has undergone a profound transformation. Scholars, practitioners, and educators have come together to envision a future where legal education is not only responsive to the evolving needs of society, but also serves as a catalyst for positive change. As we reflect on the insights shared and the visions outlined, several key themes emerge, each offering valuable insights into the path forward. The call for adaptability is mirrored in the decentralized model, where the rigid structures of traditional law schools make way for a more flexible, personalized approach, empowering students to craft their educational journey, fosters a sense of ownership, preparing them for the dynamic nature of legal practice. This decentralization, coupled with micro-credentialing, ensures that our legal professionals possess a nuanced set of skills and qualifications tailored to their aspirations. The blended law school model encapsulates the harmonious integration of tradition and technology. By maintaining the essence of traditional teaching methods of core subjects and embracing the digital realm of electives, we strike a balance that merges depth with flexibility. Experiential learning at the best of this model bridges the gap between theory and practice, molding students into well-rounded professionals poised to make a real impact. Shift from niti to nyaya resonates with our discussions. As we envision the future of legal education, it is not just about organizational propriety, but about realized justice. In this pursuit, inclusivity becomes paramount. Moreover, the digitization of legal education is not a mere option, but a necessity. In aligning with national campaigns like Digital India, legal education must harness technology for efficient learning environments and equip students to face the challenges posed by digitization. Moreover, our discussions have understood the need for legal education to embrace technology as an enabler rather than a disruptor. Harnessing the power of digital platforms, artificial intelligence, and data analytics can enhance pedagogical methodologies, promote accessibility, and facilitate experiential learning opportunities. By integrating technology into legal curricula, we empower students to engage with legal issues in real time, properly assimilate the legal principle in his mind and heart, not only by cramming, but understanding the core of the judicial principles, while learning in the vernacular is the essence of law, because unless one learns the essentials of law in its true sense, he will not be able to deliver justice when time comes, either as a practitioner or as an academician or as a judge. Vernacularization is one very important aspect, and the Government of India has been trying to vernacularize the judgments, at least for the in the beginning, by translating the judgments of Supreme Courts and different high courts in different vernaculars. It is also important to recognize that the judiciary has an indispensable role in enacting and interpreting laws. Multitudinous landmark judgments have rigorously affirmed that legal education in India must undergo substantial reformation and be modified regularly. Deepak Sibbal versus Punjab University and the Bar Council of India versus Aparna Basu Malik are these two important judgments. Then another aspect looking the way forward is the decentralization of legal education. In the decentralized legal education scenario, the traditional model of law school is disrupted by the emergence of alternative educational platforms and micro-credentializing. That is what precisely Professor Sri Raj Kumar was trying to emphasize. The concept of a law degree is replaced by a more flexible and personalized approach to legal education. Students can choose from an array of legal courses offered by various providers, including universities, law firms, online platforms, and even governmental agencies. Law schools, in response to this shift, transform themselves into learning hubs rather than mere degree providers. They offer individual courses, workshops, seminars, and short-term professional development programs. Students can choose to take a course on contract law from one law school, a course of technology law from another online platform, and a negotiation workshop from a different law firm. They can design their own learning pathway, gaining knowledge and skills relevant to their career goals or interests. Micro-credentials such as digital badges or certificates are awarded upon completion of these courses or programs. These credentials validate the students' skills and knowledge, providing them with a portfolio of qualifications that they can present to employers. Time is running out, I hope. But in course of this discussion, several key points have emerged in today's session. One key point by Justice Nalini is about the ethics and professional conduct and responsibility should be made part of curriculum. And I think the House will fully agree with the proposal of Justice Nalini, because discipline as a human being, discipline as a lawyer, as an academician, and whatever way of life you are doing, this ethics and professional conduct is key to your entire life, not only as a career, in the career, but as a human being. Then Sister Justice Nagaratna has spoken about the 1-year course after the 5-year law course. Like the internship offered to the medical professionals after completion of their 4.5-year course, they undergo essential mandatory 1-year internship. That is also a very, very good suggestion, and we must look into it. The academicians are sitting here, they may propose. Then another thing, brother, Mr. Masoom Billah, Dean of Law, Jagannath University, Republic of Bangladesh. That is he has coined the word, and I have heard it for the first time, and I would like to repeat it whenever given the opportunity, the jurisprudence of patriotism. Every sovereign country must have this jurisprudence of patriotism. Unless you have the feeling for your own country, your motherland, your everything in life, you cannot contribute to your profession, your family, your neighbor, your locality, your constituency or your state, unless you have that inner feeling of doing good for your nation, doing whatever is possible in life which you can give to your nation back. So that is one very good coinage which Mr. Masoom has given. Though his name is Masoom, whether he understands that Hindi meaning of that Masoom is not, that is innocent. And he is really innocent. I have two suggestions to make at the end of it for this organization, this Commonwealth Legal Education Association, that we should think of starting this exchange of interns amongst Commonwealth countries. If not the exchange of students amongst the nations of Commonwealth, at least to begin with, we can start exchange of interns. Then we can think of publishing a journal of Commonwealth countries. The development of law and the development of legal education, we can think of initially half-yearly journal or quarterly journal, but there may be an editorial board of contributing the members of each of the country, and then one journal, so that we are aware of the latest development in our Commonwealth countries. Because we have the common source of law. Though I also agree with one of the speakers that decolonization of law is a must. And our country, our government has already begun this by introducing those two enactments, replacing IPC, CRPC and Evidence Act with the new legislations. And we hope the government will come with more such legislations. Decolonization is the need of the hour. We have to love our own nation, and with it is not that we are doing it for the sake of fun. We are now, after 1947, it is 75th years of independence, 75th years of republic, and we must move forward with our experiences in last 7 to 8 decades, with the learnings which we have heard. As we say that the law keeps on developing every decade. Law is an organic instrument. Our constitution is organic. If our constitution can be organic, why should not the other laws be organic and develop, responding to the need of the situation? That is how I have summed up, and thank you for the organizers giving me the opportunity, and wish very soon we will have another conference of this nature. Thank you so much.
Thank you, Honorable Justice. I invite Mr. K.R. Ayyapamani, Vice President CLIA India and Member Bar Council of Tamil Nadu, to propose vote of thanks.
Yadum Ure Yavarum Kelir. That is the wonderful episode which has been incorporated 3000 years back by Tamil poet Pu Kondanar in his literature Purananur. Yadum Ure Yavarum Kelir. I am world citizen. Every citizen is my own kith and kin. That is the principle of CLIA. All brother members of legal fraternity, judicial, law students, law academians are all my brothers and sisters. I thank all for participating in the first conference of CLIA, that is on the Commonwealth Advocate Generals and Solicitor Generals Conference. You are all fortunate to be the part of the conference. I am indebted to my mentor, Chairman of CLIA, Professor Shivakumar, the living legend of Madhav Menon, who resembles his ideologies. Professor Shivakumar is the person who conceived this ideology of holding this conference. Our heartfelt gratitude to great law academician, legal luminarian, proud Attorney General of India, Senior Advocate R. Venkatramani sir. And our beloved Solicitor General, Advocate Shri Tashkar Mehta, Senior Advocate, who are the Constitution legal aids of Indian Constitution, who are the reason for hosting this wonderful conference to enlighten the legal minds of all the Commonwealth countries. Further, the prime factor was behind the entire success of the conference is the People's Judge, Honorable Justice Suryakant, Patron-in-Chief of CLIA, who meticulously contributed for conducting this conference. And I express my gratitude to all of the lost benches of this conference, future pillars of the legal fraternity, my beloved law students. Coming to these technical sessions, the topic is transforming the legal education for future, a roadmap. Molding the future legal education reimagined. Rethinking legal education are all not the topics. They are the dreams of the father of modern legal education in India, Dr. late Madhav Menon. He only advocated the legal system modern education. He is the reason for the establishment of national law schools in India. Now, the India has transformed and creating awareness among the tender age children about the POCSO Act, prevention of sexual offences against the children, and advocating the bad and good age in the tender age children. So it is necessary to impart legal education right from the schooling itself is the important of these sessions. We have to impart legal education to the young minds of the children not only studying in the law school. They should know what is the basic rights of every citizen in their nation. I express my sincere gratitude to all of the participants as the convener of the reception and protocol committee. I express my special thanks to Advocate Mrs. Vijayalakshmi Venkatramani Amma. She is always a mother, showed and proud affection to every one of the CLIA. One more thing I have to share. Our Attorney General is the first Attorney General of India to have his spouse as a practicing advocate. She is a practicing advocate in Supreme Court. So, and I am thankful to my secretaries of Madam Meera. She has come from London. And my Secretary Advocate of Supreme Court, Vikram Singh Arya, and our CLIA Secretary India, Madam Professor Lisa, and all to the staff of the Prime Minister's Office, Law Minister's Office, Departmental Office, and also especially Mr. Subramani and Jimmy Matthew of Attorney Office, and all the volunteers of Indian Law Institute, Dean and Management and Faculty of Law Schools who actively attend the conference. At last, the entire team of CSF and Vigan Bhavan staff. I thank Mr. Vinay Ahuja Mohan of Mohan Law House, Delhi for his support to the conference. I am coming to the technical sessions. I thank Honorable Justice Madam for delivering a wonderful speech and for chairing these technical sessions. My special thanks to Honorable Justice Prashant Kumar Mishra, Judge Supreme Court of India, who has always encouraged young lawyers in his court, for co-chairing these technical sessions. Thanks to Honorable Justice Sri Tatut Talni Patmanathan, Judge Federal Court, Malaysia. And it was a sweet and short welcome address. My beloved brother, Mr. Vikramji Banner, Additional Solicitor General of India. And other speakers, Frank D. Ali, Attorney General, Republic of Chile. Mr. Lennon Hyun Sin, Deputy Attorney General, Republic of Singapore. Mr. Dabu Chakkar Nirendra, Attorney General, Republic of Malawi. Professor Dr. A. Kumaralingam, Professor of Law, National University of Singapore, CLIA, South India. Dr. Sudhir Krishnaswamy, Vice Chancellor, the most prestigious law school of India and oldest school of India, National Law School, Bangalore. Ms. Devan Hong, Solicitor General, Republic of Singapore. Mrs. Zhu, Solicitor General, Republic of Ghana. Professor Mazwim Billah, Dean of Law, Jagannath University, Republic of Bangladesh. My beloved brother, Professor Dr. C. Rajkumar, Vice Chancellor, O.P. Jindal Global University, Haryana. Mr. Alfred Chok, Deputy Attorney General of Ghana. Ms. Hana Habubakar, Attorney General, Borno State, Niagara. Thanks for honor all. Jai Hind.
I request all of you to reassemble in the plenary hall at sharp 3:30 p.m. after lunch and networking for the valedictory function to be graced by the President. Guests, foreign delegates are requested to assemble in hall number 1 at 2:45 after lunch. Thank you. I request all of you to carry your belongings because now the security people will be taking it over to get it ready for Honorable President's arrival. So please carry.
The Honourable Minister of State with independent charge for Law and Justice, Government of India, Shri Arjun Ram Meghwal, is also with us. In a few seconds, the Honourable President of India, Srimati Draupadi Murmu, will join us. Over the last 2 days, we've had 5 sessions to address pressing issues. Ladies and gentlemen, the President of India. Please remain standing now for the national anthem. May I now request the Conference Chair and President of the Commonwealth Legal Education Association, Senior Professor at the Indian Law Institute, Professor Dr. S. Sivakumar, to please welcome all our esteemed delegates and guests and also present the conference report.
Honorable President Srimati Draupadi Murmu, Madam, Honorable Home Minister and Minister for Corporation, Sri Amit Shah Ji, Chief Patron, Honorable Mr. Justice Suryakant, Judge Supreme Court of India, Honorable Minister for Law and Justice, Sri Arjun Ram Meghwal, dignitaries on the dais and off the dais. It is my proud privilege to extend a warm welcome to the Honorable President, who graces our unique event as Chief Guest of today. Across Madam's illustrious career, Madam has consistently shown a steadfast dedication to championing social justice and the principles of rule of law. We express our sincere gratitude for your presence, Madam President, which truly enhances the significance of our gathering. We warmly welcome Sri Amit Shah Ji, Honorable Home Minister and Minister for Cooperation, as guest of honor today. His exemplary leadership has been pivotal in shaping crucial policies for the government and criminal law reforms. We deeply appreciated and recognize the invaluable guidance provided by you, sir. We thank our Chief Patron, Honorable Mr. Justice Suryakant, Judge Supreme Court of India, for his wholehearted blessings and the patronage for the implementation of this conference. We also express our gratitude to Sri Arjun Ram Meghwal, the Minister for Law and Justice, for the support and guidance. Learned Attorney General Dr. R. Venkatramani, Mr. Tushar Mehta, Solicitor Generals, are the two pillars for this initiative. The success of this conference is their guidance and advice. As President of Commonwealth Legal Education Association and the conference chair, once again welcome and thank our attorneys and solicitors, members of delegation from Commonwealth nation. Your commitment to this cause is the success of the conference, and I sincerely appreciate each one of you for the same. Madam President, let me come to the brief report part. The Commonwealth Attorneys and Solicitor General Conference 2024 started on high note after being inspired by the visionary leadership of the Honorable Prime Minister of India. The international conference spanned 2 days, covered diverse themes and sub-themes. The event, guided by overreaching motto, from the vision to action, shaping the future of legal education and justice delivery in the Commonwealth, brought together legal luminaries globally. This gathering transcended local legal studies addressing collective global concerns. The active participation of attorneys and solicitors from various Commonwealth countries underscored a commitment to the conference vision. Rather than solely identifying the challenges, the focus extended to actively contributing to the evolution of legal education and justice delivery. Roundtable discussion played an important role in fostering open dialogue by navigating the complexities of cross-border justice to solution-oriented approach. Thus, the conference conclusion has left a lasting impact on shaping trajectory of legal education and justice delivery within the Commonwealth. Once again, I warm welcome to our distinguished guests and participants to the valedictory ceremony. Thank you.
May I now request the Attorney General of India and the Chairperson of the Organizing Committee, Dr. R. Venkataramani, to please present a memento to the Honorable President of India. May I request Dr. R. Venkataramani to also present a memento to the Honorable Minister for Home Affairs and Cooperation. To give us the overview of the conference, may I now invite the co-chair of the Organizing Committee and the Solicitor General of India, Shri Tushar Mehta.
A very good evening to all of you. The Honorable President of India, the Honorable Home Minister and Minister for Cooperation, Shri Amit Shah ji, the patron of the conference, Justice Suryakant, Senior Judge, Supreme Court of India, Shri Arjun Ram Meghwal ji, the Honorable Law Minister, the Honorable Judges of the Supreme Court of India and other courts, the Honorable Chief Justices of various High Courts, and dignitaries and friends. We have witnessed the first of its kind event where law officers of all Commonwealth countries participated in one of the most relevant subjects and one of the most crucial problems being faced by the present times by global world. India has always been leading the world in all spheres of life, and justice delivery is not an exception. Like most of the developed countries, India is also facing cross-border issues which can be broadly classified in two broad categories. First, infiltration through porous borders of India, as India has one of the longest borders in the various countries of the world. And second, the criminals committing crime in India, whether economic offenses or otherwise, crossing over to the geographical boundaries of India and taking refuge in neighboring countries. Under the leadership of our Honorable Prime Minister and the Honorable Home Minister, who is known for his iron will and his futuristic vision, India is tackling both the problems very effectively and efficiently. India is a signatory to Vienna Convention and Palermo Convention, and therefore India is committed globally on the global foundation and framework to deal with all economic offenses and economic offenders in tune with the global regime which is made available under the aegis of the United Nations. India is making all attempts to have mutual legal assistance among all countries of the world so as to ensure that offenders of law are brought to book, they are brought to India to face the trial before the Indian courts, of course strictly in accordance with the Constitution of India. In any case, they require a kind of relook. The way in which the nature of offenses are changing, the way in which the modus operandi of the offenders are changing, and the societal changes requires every country to have a relook at their respective penal laws. Friends, though this is not the subject matter of a direct discussion in the present conference, but I am tempted to flag this issue for one simple reason. We all Commonwealth nations have inherited one thing in common, and that is the laws made during the colonial era. India has now ventured into normalizing the penal laws of India, keeping in pace with and bringing the law in tune with the societal realities, and from punishment regime to the justice regime. The reason is quite clear. For Britishers, we were all subjects, we were all natives. Now the government is dealing with the citizens of the country, and therefore justice takes precedence over punishment. Under the visionary guidance of our Home Minister, who is fortunately present, for the first time, India has made several legislative changes in its three penal laws, namely the Criminal Procedure Code, Indian Penal Code, and the Indian Evidence Act. All three of have their genesis in the colonial era laws. For the first time, India has introduced community service as one of the forms of punishment, of course for the petty offenses like not responding to the summons or not being present despite proclamation of offender, etc. India has also changed the priority of the offenses, since the priority of the colonial era regime was completely different than the democratic republic which India has become. India has given tremendous prominence to offenses against women, and for the first time, age-based parameters for punishment is done away with, and this is one of the revolutionary steps which the Indian Parliament has taken. The colonial era law of sedition is also suitably redefined so as to bring it in conformity with the present constitutional parameters and bring it in tune with Part 3 of the Constitution of India, which contains fundamental rights given to the citizens of India. The purpose of my sharing these ideas, despite this not being the direct subject, is to ensure that since we have a common statutory regime legacy, and since India has made a first move, I would request all Attorney Generals and Solicitor Generals, my colleague law officers, to ensure that in their respective countries also, this change is reflected in their respective decision making. There is yet another very bold move which India has initiated, and I would request all my colleague law officers from across the Commonwealth countries to take up in their respective countries. Friends, during the regime of colonial era, where we were subjects, we were subjected to several statutory laws which have become either obsolete or they are not in tune with the fundamental principles of our constitutional morality. The Indian Parliament has repealed thousands of laws of British colonial era and ensured that unnecessary compliance by the citizens is done away with. Friends, this two-day conference is not an end by itself. Let us take this as a beginning. Let us take this as an opportunity to find the way forward, and in consultation with each other and with full legislative cooperation, let us help each other in dealing with the cross-border justice delivery issue effectively, efficiently, and in conformity with the constitutional principles of our respective constitutions. Friends, you are all most welcome to share anything with my senior, the learned Attorney General, or with me, or any of my colleague law officers. If you need any guidance, any help, any assistance, any details or data with regard to the statutory regime changes which are taking place very rapidly in India, you are most welcome to do that. Thank you so much.
To share with us the roadmap ahead, may I now request the Chairperson of the Organizing Committee and the Attorney General of India, Dr. R. Venkataramani.
Honorable President Srimati Draupadi Murmu, Honorable Home Minister Shri Amit Shahji, my dear Minister for Law and Justice, respected dignitaries in the dais, the conference is twice blessed. First, the inaugural address by the Honorable Prime Minister, and now we have the gracious and distinguished presence of the Honorable President. We feel encouraged. I'm sure the guests from abroad who have braved traveling long distances will carry back with them warm and inerasable memories of the conference. All of us who assemble here, I have common concerns domestically. Each one of us think and work towards promoting equal regard for all and equal welfare of all. Our constitutions have universal principles and values. The striving in each of our nations is to ensure these values. The break from the past in terms of dictations from outside has unleashed the genius and potential of all the peoples. No debate in any meetings and associations of people is possible today without reference to technology changes. No discussions can be complete without critically looking at the domestic legislations and the international legal instruments which are still rooted in divisive elements. Equal partnership means that which should be shared and that which should be given up. Public international law is still driven by global power equations. Private international law is still stuck with clashes between legal systems and procedures. We should no longer be talking about conflict of laws. Confluence of laws and convergence of judicial systems without sacrificing special features will be our global quest for justice. What is important, however, is how to connect legal education to all these aspects. Legal education cannot remain away from comparative exposures and new legal transplantations. We have to draft inter-country collaboration and cooperation in transforming our legal education with global responsibilities and global task agenda. We shall draft common principles on cross-border crimes protocols and present them as relevant models for global reception. We need to draft model trade and commerce protocols for Commonwealth countries. We may have a Commonwealth Prosecutors Association who can enable effortless and frictionless cross-border investigation and prosecutions. Maybe we should think about setting up a Commonwealth country's criminal tribunal or to move towards governmental recognition of courts in each country as competent to deal with cross-border crimes. For all this, we need to set up a free countries of Commonwealth legal exchanges platform. This conference, as I said in the inaugural session, that can be designated as the New Delhi Convention of the Commonwealth Law Officers. And I take that I have the liberty to say that we have commonly resolved that we establish a Commonwealth Alliance for Global Visions. And in this regard, to set up, one, the Commonwealth Legal Education Partnership Platform beyond the scattered exchange programs, which will endeavor to provide insights to transform legal education as a social assistance education, where knowledge and ethics will outweigh the glitter of opulence and which can balance the role of innovations and current needs, which will connect current university networks, and finally, which will also encourage practitioners of law and promote inclinations to serve judicial and other public institutions. Two, Commonwealth Legal Education Transborder Institute. Number three, the Commonwealth Attorney General's platform to fashion cross-border legal facilitation instruments and inter-country criminal justice assistance. Number four, inter-country confluence of civil laws and justice systems to enable and facilitate inter-country trade and commerce exchanges to close the gaps in current conflict of laws. And five, to work towards a Commonwealth arbitration and mediation platform to provide for inter-country dispute resolutions. Number six, to encourage inter-country programs on access to justice. And finally, a Commonwealth Legal Education Secretariat to work towards eventually moving into a free countries compact to transform the landscapes of legal education and to create our institutions as world-class institutions to provide for student and institutional exchanges. The migration will now be to the global south. And finally, there need be no transatlantic or trans-Pacific migration in the search for exposures and excellence. I warmly thank the Honorable President for being with us today and blessing us. Your presence has enlivened the participants who have traveled long distances to share their common concerns. I thank the Honorable Home Minister who has encouraged and supported this initiative, and I'm sure he will continue to be in support of the follow-up work. I thank the guests. And we also have shared inter-country best practices in the deployment of digital technology in enhancing access to justice and justice delivery, legal literacy and legal awareness, and court practice and procedures. I thank the guests from abroad plentifully, and I say this New Delhi Convention will be a new chapter on free exchanges. Thank you so much.
May I now request the Minister of State with independent charge of Law and Justice, Government of India, Shri Arjun Ram Meghwalji, to please address the gathering.
Commonwealth Attorney and Solicitors General Conference 2024 के समापन सत्र पर सम्मानित मंच पर उपस्थित हम सबको ऊर्जा देते हुए मार्गदर्शन प्रदान कर रही परम सम्माननीय भारत की राष्ट्रपति श्रीमती द्रौपदी मुर्मू जी, सुरक्षित, सशक्त एवं समृद्ध भारत के निर्माण में पूर्ण मनोयोग से संकल्पित भारत के गृह एवं सहकारिता मंत्री आदरणीय श्री अमित शाह जी, ऑनरेबल जस्टिस सूर्यकांत जी, जज सुप्रीम कोर्ट ऑफ इंडिया एंड चीफ पैटर्न ऑफ कॉमनवेल्थ लीगल एजुकेशन एसोसिएशन, लर्नेड अटॉर्नी जनरल ऑफ इंडिया एंड पैटर्न CLEA डॉक्टर R. वेंकट रमणी जी, लर्नेड सॉलिसिटर जनरल ऑफ इंडिया श्री तुषार मेहता जी, प्रेसिडेंट CLEA and Senior Professor, Indian Law Institute, Professor Dr. S. Shiv Kumar जी, तथा उपस्थित माननीय सुप्रीम कोर्ट एवं विभिन्न हाई कोर्ट से आए हुए न्यायाधीशगण, कॉमनवेल्थ देशों से आए हुए न्यायाधीशगण, अटॉर्नी जनरल्स एवं सॉलिसिटर जनरल्स, राज्यों से आए हुए एडवोकेट जनरल्स, समस्त अधिवक्तागण, शोधार्थी, विद्यार्थी, मीडिया बंधु, नारी शक्ति एवं समस्त उपस्थित एवं डिजिटल प्लेटफॉर्म से जुड़े हुए सभी नागरिकगण, सबको नमस्कार। क्रॉस बॉर्डर चैलेंजेस इन जस्टिस डिलीवरी के विषय पर आयोजित इस 2 दिवसीय कॉन्फ्रेंस में कॉमनवेल्थ देशों में कानूनी शिक्षा और न्याय प्रदान करने के सभी पहलुओं, चुनौतियों पर चिंतन, मनन एवं मंथन करके प्रभावी समाधानों पर विचार विमर्श किया गया। मैं सभी प्रतिभागियों को अनंत शुभकामनाएं प्रेषित करता हूं। भारत के परिप्रेक्ष्य में देखा जाए तो यह भारत के संविधान निर्माताओं की बुद्धिमत्ता व दूरदर्शिता का ही परिणाम है कि भारतीय संविधान की प्रस्तावना में ही, प्रीएम्बल में ही नागरिकों को सामाजिक, राजनीतिक और आर्थिक न्याय प्रदान करने की बात कही गई है। इसी न्याय की भावना को बलवती करते हुए भारत के यशस्वी प्रधानमंत्री श्री नरेंद्र मोदी जी के नेतृत्व में हमारे गृह मंत्री श्री अमित शाह जी के द्वारा इंडियन पीनल कोड, क्रिमिनल प्रोसीजर कोड, इंडियन एविडेंस एक्ट, जो पीनल व पनिशमेंट को प्राथमिकता में रखकर अंग्रेजों द्वारा बनाई गई थी, के स्थान पर न्याय की भावना को मूल में रखकर नई न्याय प्रणाली के रूप में भारतीय न्याय संहिता, भारतीय नागरिक सुरक्षा संहिता, भारतीय साक्ष्य अधिनियम को पारित करके जो संविधान निर्माताओं ने परिकल्पना की थी, उसको उन्होंने साकार किया है गृह मंत्री जी ने। इसी व्यवस्था के अंतर्गत पहली बार टेररिज्म, ऑर्गेनाइज्ड क्राइम, साइबर, इकोनॉमिक ऑफेंसेस जैसे क्रॉस बॉर्डर नेचर के अपराधों को परिभाषित भी किया गया है। मुझे विश्वास है कि जिस प्रकार जस्टिस की स्पिरिट को ध्यान में रखकर नई व्यवस्था को भारत में लागू किया जा रहा है, हर क्षेत्र में कानूनों को रीड्राफ्ट करने या वर्तमान समय अनुसार नया बनाने का प्रयास किया जा रहा है। ये बदलते परिवेश में कॉमनवेल्थ के अन्य सदस्यों के लिए भी उपयोगी होगा। इस 2 दिवसीय कॉन्फ्रेंस के इनॉग्रल सेशन में भारत के युगनायक प्रधानमंत्री श्री नरेंद्र मोदी जी ने मार्गदर्शन देते हुए कहा था कि आज 21वीं सदी की चुनौतियों को 20वीं सदी की सोच से ठीक नहीं किया जा सकता। हमें 21वीं सदी का सोच ही लाना पड़ेगा और इसी क्रम में जस्टिस डिलीवरी को एफिशिएंट बनाने तथा नागरिकों को ईज ऑफ लिविंग मुहैया कराने की दिशा में पिछले 10 सालों में 1562 इर्रिलेवेंट और अननेसेसरी कानूनों को हटा दिया गया है। इससे एडवोकेट फ्रेटर्निटी के लिए भी ईज ऑफ वर्किंग का मार्ग प्रशस्त हुआ है। भारत सरकार द्वारा आर्बिट्रेशन लॉ, मीडिएशन लॉ, जन विश्वास बिल तथा कंपनीज एक्ट के अंतर्गत माइनर इकोनॉमिक ऑफेंस को डीक्रिमिनलाइज करने संबंधी संशोधन द्वारा जुडिशरी पर बर्डन कम करने का सराहनीय प्रयास भी मोदी जी के नेतृत्व में हुआ है। देश में ईज ऑफ डूइंग बिजनेस को बढ़ावा देने के लिए 40,000 से अधिक कंप्लायंस बर्डन को भी कम किया जा चुका है, जो कि मिनिमम गवर्नमेंट मैक्सिमम गवर्नेंस का परिचायक है। इसके माध्यम से नागरिकों का एक महत्वपूर्ण समाज बनाने की दिशा में संस्थाओं में विश्वास बढ़ा है। इस 2 दिवसीय कॉन्फ्रेंस के दौरान आयोजित टेक्निकल सेशन में एक्सेस टू जस्टिस, टेक्नोलॉजिकल एडवांसमेंट एंड लीगल डायनेमिक्स ethics and accountability in legal practice, हार्मोनाइजिंग लेजिस्लेटिव लैंडस्केप जैसे सब थीम्स पर विस्तृत चर्चा की गई है। यह कॉन्फ्रेंस कॉमनवेल्थ देशों के मध्य जस्टिस डिलीवरी सिस्टम की बेस्ट प्रैक्टिसेस का आदान प्रदान करने तथा आज की वैश्विक समस्याओं के समाधान की रूपरेखा बनाने की दिशा में एक महत्वपूर्ण कदम है। मुझे विश्वास है कि इस कॉन्फ्रेंस में दिल्ली डिक्लेरेशन ऑन जस्टिस डिलीवरी सिस्टम्स के टेंजिबल आउटकम को सस्टेन करने की दिशा में कॉमनवेल्थ सदस्यों के मध्य आपसी सहयोग व संवाद निरंतर बना रहेगा, ताकि हम सब मिलकर मानवता के कल्याण के साथ भावी पीढ़ियों को उच्च मानकों से परिपूर्ण एक बेहतर भविष्य प्रदान कर सके। अंत में लोकतंत्र की जननी भारत के विराट सांस्कृतिक वैभव से सिंचित प्रेरक मूल्यों को रेखांकित करते हुए 4 पंक्तियां कहना चाहता हूं। दुनिया पर शासन करना था, ये मैं जो हमारे ऊपर जो शासन करना आए थे उनके लिए कह रहा हूं। दुनिया पर शासन करना था तो जग को दंड विधान दिया, दुनिया पर शासन करना था तो जग को दंड विधान दिया, पर हम समरसता वाले हैं, हमने सबको सम्मान दिया। जनता का राज रहे अपना, जन जन को सच्चा न्याय मिले। जनता का राज रहे अपना, जन जन को सच्चा न्याय मिले। हर जीवन हो सुख में निर्भय, हर होठों पर मुस्कान खिले। इसलिए कई कानून मिटे, निर्णय हम नए ले रहे हैं। हम दंड विधान नहीं, सबको न्याय विधान दे रहे हैं। जय भारत।
May I now request the Chief Patron, Honorable Judge of the Supreme Court, Mr. Justice Suryakant, to please share his thoughts with us.
Honorable President of India, Srimati Draupadi Murmu ji, Honorable Union Minister for Home Affairs and Cooperation, Shri Amit Shah ji, my esteemed brother, Judges of the Supreme Court of India, respected Minister of Law and Justice, Shri Arjun Ram Meghwal ji, learned Attorney General for India, Dr. R. Venkataramani, learned Solicitor General of India, Mr. Tushar Mehta, Justice Zone Alexander Logan, Judge, Federal Court of Australia, Justice Lanini Padmanathan, Judge, Federal Court of Malaysia, Justice J. A.V.M. Hassan, Judge, Supreme Court of Bangladesh, Justice S. Thuri Raja, Judge, Supreme Court of Sri Lanka, Chief Justices and Judges of the High Courts, learned Attorney Generals, Solicitor Generals and law officers from various Commonwealth countries, Professor Dr. S. Shivakumar, President, Commonwealth Legal Education Association, senior advocates and members of the Supreme Court Bar Association, learned Vice Chancellors, jurists, academicians, delegates, representatives, distinguished guests, my dear law students, a very good evening. It gives me profound pleasure to extend a warm welcome to all of you to the valedictory ceremony of the Commonwealth Attorneys and Solicitors General Conference 2024. It is my sincere belief that this august gathering has been able to transcend boundaries and unite legal minds from diverse corners of the globe. With the culmination of this valedictory ceremony, the curtains gracefully descend on this monument event. As the chief patron of this conference, I seize this moment to convey my immense gratitude to each and every individual whose valuable contributions have made this event a great accomplishment. I extend my heartfelt appreciation to the esteemed dignitaries assembled here today for their steadfast support and enduring patronage and playing a significant role in the resounding success of this event. I would also like to thank all the distinguished Attorneys General, Solicitor General and delegates representing 30 Commonwealth countries for their active participation, insight and unwavering dedication to the cause of justice. Your presence has bridged geographical distances and forged bonds of collaboration that extends beyond borders. I appreciate the dedicated efforts made by Dr. R. Venkataramani, learned Attorney General for India, Shri Tushar Mehta, learned Solicitor General, and Professor Dr. S. Shivakumar, President, Commonwealth Legal Education Association, who have been the driving force behind the pleasant outcome of this conference. I convey my special thanks to the faculty of Indian Law Institute for their wholesome contribution in organizing this event. The salutary purpose behind organizing this conference was to establish a forum for a substantive dialogue on justice delivery, quality legal education, and fostering togetherness among Commonwealth nations and beyond. With its rich tapestry of cultures, legal traditions, and histories, the Commonwealth is a compelling illustration of the potential inherent in utility amid diversity. I am extremely thankful to my colleagues from the Supreme Court of India for their invaluable participation in the conference and for their perspectives on complex global legal issues. I also wish to convey my deep appreciation for the enlightening and stimulating discussions facilitated by our esteemed delegates and law officers hailing from diverse Commonwealth jurisdictions. Their wide range of experience and expertise has immensely helped this conclave in delving into nuanced issues persisting within global justice delivery. The presentations they made were not only informative but also exemplified their dogged determination to the principles of justice, rule of law, and legal education. Their varied views and wealth of experiences enriched our ongoing discourse and propelled us towards innovative solutions and heightened global cooperation. I am also deeply touched by the sentiments that were shared by some distinguished participants during the technical sessions. Some of them recounted their Indian ancestry and became nostalgic as to how this conference has occasioned them to return to their very shores that their ancestors departed from several centuries back. We are delighted that this platform has provided you with an opportunity to reconnect with your roots. Over the course of last 2 days, the delegates engaged in thought-provoking conversations which have enhanced our understanding of legal complexities and laid the groundwork for concerted efforts to improve the global legal landscape. The deliberations during this interchange has shed light on the complex endeavor of harmonizing legislations across the Commonwealth. The legal systems governing the participating countries promote us to seek common solutions while preserving their autonomy and distinctive legal traditions. It is a matter of immense satisfaction that we could successfully engage in discussions on the ethical dimensions of the legal practice and the evolving role of judiciary in a changing world. There were extremely informative and refining outlooks on how to tackle the transnational crimes. The importance of reforming legal education for the future has also been duly emphasized. While these issues present multifaceted challenges and as many impediments before justice delivery system and perhaps even to the legal professionals, a common thread that unified them all is the imperative need for a collective approach to be adopted by the Commonwealth nations in addressing these ever-emerging issues. The pursuit of a somewhat congruous legislative framework demands a nuanced approach that safeguards the essence of individual legal systems and also encourages collaborations based on shared principles. The deliberations on the theme and sub-themes explored during the conference have made us embark on a journey that goes beyond rhetoric. Each session has been a stepping stone towards a more just and resilient legal landscape. The conference resolved that the role of judiciary in a changing world is dynamic, which necessitates the adaptation to new technologies and ensuring accessibility to one and all. Our legal systems need to be resolute to the complexities that go beyond geographical limitations and harness technology-driven legal practices. The brainstorming sessions have given us a perspective, a roadmap as to what more is needed to be done. These also serve as a reminder of the work that still remains to be initiated. We are conscious of the fact that there is no one-stop solution, but we are equally determined to engage in continued collaboration, research, and proactive efforts to enact a positive change. Knowing well that legal education is a crucial pillar in molding the future of a nation and the entire globe. Once again, I extend my thanks to all the participants for their active involvement, dedication, and intellectual contributions. As we move forward, let us carry the spirit of mutual effort and engagement beyond these walls. The corrections forged and ideas exchanged during this conference lay the groundwork for transformative legal education, institutional preservance, and a justice delivery system that does not limit itself to man-made boundaries. Let the impact of this conference reverberate in the corridors of justice, the classrooms of legal education, and the hearts of all those dedicated to upholding the principles of fairness, equality, and justice. Thank you, each and every one of you, for being integral to this extraordinary journey. Thank you very much.
May I now invite the guest of honor, the Union Minister for Home Affairs and Cooperation, Shri Amit Shah, to address the illustrious assembly.
आज के इस बहुत महत्वपूर्ण कार्यक्रम में हम सबके बीच में उपस्थित भारत की महामहिम राष्ट्रपति श्रीमती द्रौपदी मुर्मू जी, सर्वोच्च अदालत के न्यायमूर्ति श्रीमान सूर्यकांत जी, मोदी जी की मंत्रिपरिषद में मेरे साथी श्री अर्जुन राम मेघवाल जी, डॉक्टर आर वेंकटरमणी, अटॉर्नी जनरल ऑफ इंडिया, श्रीमान तुषार मेहता जी, सॉलिसिटर जनरल ऑफ इंडिया, डॉक्टर एस शिव कुमार, जिनके निमंत्रण पर हम सभी लोग यहाँ पर आए हैं, अध्यक्ष कॉमनवेल्थ लीगल एजुकेशन एसोसिएशन, और उपस्थित सभी न्याय क्षेत्र से जुड़े हुए सभी कॉमनवेल्थ कंट्रीज से आए हुए अलग अलग भूमिका को निर्वहन करते हुए भाइयों और बहनों, आप सभी को अंतिम दिन पर ही सही मैं भारत में आप सभी का स्वागत करता हूं। मित्रों, कॉमनवेल्थ लीगल एजुकेशन एसोसिएशन द्वारा आयोजित कॉमनवेल्थ अटॉर्नी एंड सॉलिसिटर्स कॉन्फ्रेंस मुझे यहाँ पर बुलाकर मेरे विचार रखने का मौका जो दिया, इसके लिए सबसे पहले मैं आप सभी का बहुत बहुत धन्यवाद करना चाहता हूं और आभार व्यक्त करना चाहता हूं। विशेषकर ये कॉन्फ्रेंस ऐसे समय में हो रही है जब जियोग्राफिकल बाउंड्री का विश्व में कोई महत्व नहीं रहा है, ना कॉमर्स के लिए रहा है ना क्राइम के लिए रहा है। कॉमर्स भी बॉर्डरलेस हो रहा है, क्राइम भी बॉर्डरलेस हो रहा है, और उस वक्त कॉमर्स के डिस्प्यूट और क्राइम, इसको भी अगर बॉर्डरलेस तरीके से हमने निपटना है तो हमें कोई ना कोई नई व्यवस्था, नई परंपरा शुरू करनी पड़ेगी। इसलिए आज की ये कॉन्फ्रेंस का जो विषय है वो भी इतना ही रिलेवेंट है और समय भी बहुत रिलेवेंट है, ऐसा मेरा मानना है। मैं एक बात, आप सभी लोग शुद्ध रूप से कोर्ट के साथ जुड़े हुए हैं, न्याय की प्रक्रिया के साथ जुड़े हुए हैं। आप सभी को मालूम है आम व्यक्ति के जीवन में न्याय का कितना महत्व है और कितनी श्रद्धा है, परंतु इसकी अभिव्यक्ति अभी अभी महामहिम राष्ट्रपति ने एक जगह पे की है, इसको मैं जरूर कोट करना चाहूंगा। महामहिम राष्ट्रपति यहां से सुदूर 1000 किलोमीटर दूर भारत के सबसे पिछड़े इलाके से और सबसे पिछड़ी ट्राइब से भारत के राष्ट्रपति तक पहुंची हुई व्यक्ति है, और ये बताता है कि भारत में लोकतंत्र और संविधान की स्पिरिट की जड़ें कितनी गहरी नीचे तक, पाताल तक गई हैं। उन्होंने अभी अभी एक भाषण में मार्मिक टिप्पणी की थी उनके गांव के लोग तीन ही लोगों को भगवान मानते थे। एक शिक्षक जो बच्चों को ज्ञान देता है, आगे बढ़ाता है। दूसरा डॉक्टर जो सभी लोगों के स्वास्थ्य के दूरस्थ रखकर अच्छा सुदीर्घ आयुष्य लेने के लिए मदद करता है। और तीसरा लॉयर जो न्याय तंत्र के लिए शब्द है, लॉयर जो आम भाषा में उपयोग में आता है, वो उनको संविधान ने दिए हुए सारे अधिकारों को मुहैया कराने में मदद करता है। इसलिए मैं आज ये बात बताना चाहता हूं कि यहां पर जो कॉन्फ्रेंस हो रही है, इसका दायरा केवल कोर्ट तक सीमित नहीं है। इसका दायरा कॉमनवेल्थ कंट्रीज और एक प्रकार से पूरी दुनिया के आम लोगों के साथ जुड़ा हुआ है, क्योंकि संविधान में, हर देश के संविधान में भावनाएं भी होती है, स्पिरिट भी होता है और कुछ इथोस को ले डाउन भी किया हुआ होता है, परंतु न्याय और अधिकार सब में आपको कॉमन मिलेंगे। इसको जमीन पर उतारने का काम और उसको न्याय को आम व्यक्ति तक पहुंचाने का काम केवल और केवल न्याय तंत्र ही करता है, जिसके साथ आप जुड़े हुए हो। तो इस समय पर न्याय की नागरिकों के प्राप्ति के लिए कॉमनवेल्थ कंट्री में क्या करना चाहिए, इसकी चर्चा ये 2 दिन तक आपने की है। मैं मानता हूं कि बहुत सार्थक चर्चा हुई है। मेरे पास जो रिपोर्ट है इसमें ढेर सारे विषयों पर चर्चा हुई है, मगर ग्लोबल लीगल चैलेंजेस और इंस्टीट्यूशनल एक्सेसिबिलिटी, ये विषय मैं मानता हूं कि आज के समय में सबसे ज्यादा रिलेवेंट है और इस पर आगे पर भी एसोसिएशन ने काम करना चाहिए, क्योंकि एक प्रकार से ये चर्चा अगर यहीं रह जाती है, एकेडमिक चर्चा होकर इसके एसोसिएशन के रिकॉर्ड में रहेगी, तो इसका कोई फायदा नहीं होगा। मेरा आप सभी अटॉर्नी और सॉलिसिटर जनरल से आग्रह है कि इसके जो एक्शन पॉइंट है चर्चा के, आपके बिजनेस सेशन के जितने भी एक्शनेबल पॉइंट है, उसको आपके देश की लॉ मेकिंग एजेंसी के साथ शेयर कर लॉ को शेप देकर पूरे ग्लोबल ऑर्डर को ठीक करने का प्रयास इस कॉन्फ्रेंस के माध्यम से करना चाहिए। तभी जाकर एक कॉन्फ्रेंस एक प्रकार से सक्सेसफुल कॉन्फ्रेंस मानी जाएगी। अभी कुछ समय पहले हम बैठे थे, तब भी मैंने प्रदीप जी को भी बताया, जस्टिस सूर्यकांत जी को भी बताया कि इसको आगे ले जाने के लिए यहां से जाकर ज्यादा काम करना पड़ेगा, ऐसा मुझे लगता है। मित्रों, जस्टिस डिलीवरी में क्रॉस बॉर्डर चैलेंजेस, इसकी बात करें तो आज कनेक्ट दुनिया में जियोग्राफिकल बॉर्डर और बैरियर है ही है, इसको कोई नकार नहीं सकता, परंतु ट्रेड, कॉमर्स, कम्युनिकेशन और क्राइम, ये सब में से बैरियर और बॉर्डर, ये दोनों शब्द निकल गए हैं। क्राइम भी, फिर से एक बार मैं कहना चाहूंगा, क्राइम भी बॉर्डरलेस हो गया है और ट्रेड भी बॉर्डरलेस हो गया है। ये दोनों के लिए हमने आगे काम करना पड़ेगा। और मैं क्राइम की बात करूं तो एक प्रकार से छोटे साइबर फ्रॉड से लेकर ग्लोबल ऑर्गेनाइज क्राइम तक, ये दोनों के बीच में जुड़ाव अब बहुत गहरा होता जा रहा है। लोकल डिस्प्यूट से लेकर क्रॉस बॉर्डर डिस्प्यूट तक भी जुड़ाव बहुत गहरा होता जाता है। छोटी सी चोरी से लेकर अब बैंकिंग सिस्टम को हैक करना और डेटा को हैक करने तक की पूरी प्रक्रिया अब समाप्त हो चुकी है। और स्थानीय क्राइम से इंटरनेशनल टेररिज्म का जुड़ाव भी गहरा होता जा रहा है। आज क्राइम और क्रिमिनल दोनों बॉर्डर को नहीं मानते हैं। उस वक्त उसको कंट्रोल करने के लिए लॉ एनफोर्समेंट एजेंसी के एक सशक्त, मजबूत करने के लिए आपकी दुनिया ने भी आगे बहुत कुछ करना पड़ेगा, वरना हम क्राइम को और ट्रेड को, दोनों को, क्राइम को कंट्रोल करने के लिए और ट्रेड को सुचारू रूप से चलाने के लिए विश्व का वातावरण नहीं बढ़ा। जहां तक ट्रेड का सवाल है, एक्सचेंज रेट का उतार चढ़ाव, ट्रेड प्रोटेक्शन की ट्रीटियां, इंटरनेशनल स्टैंडर्ड्स और रेगुलेशन के कंप्लायंस से जुड़े हुए मुद्दे और कॉन्ट्रैक्ट एंड डिस्प्यूट रिजोल्यूशन, ऐसे कई मुद्दे हैं जिस पर एक कॉमन रुख लेकर आगे बढ़ना पड़ेगा। बहुत सारा काम हुआ है, मगर आज भी मैं आपको बता सकता हूं कि कई ऐसे मुद्दे हैं जहां पर क्राइम के लिए हमें काम करना पड़ेगा। और मैं ऐसा मानता हूं कि जियोग्राफिकल बॉर्डर ये मर्यादा नहीं होनी चाहिए। कानून के लिए जियोग्राफिकल बॉर्डर मीटिंग पॉइंट होना चाहिए और वो मीटिंग पॉइंट तय करने का काम इस जैसी कॉन्फ्रेंसों ने करना पड़ेगा। तभी जाकर सब कानून एक दूसरे को रेसिप्रोकेट करेंगे और हम जस्टिस की डिलीवरी कर पाएंगे। आज के टेक्नोलॉजी के दौर में जस्टिस डिलीवरी की जो कल्पना है, इसमें कोऑपरेशन और कोऑर्डिनेशन को भी हमने मूल मंत्र बनाना पड़ेगा। आज के ग्लोबल क्राइम चैलेंजेस जब सीमाओं का सम्मान नहीं करते हैं, जस्टिस डिलीवरी में भी हमने सीमाओं को एंड की तरह नहीं बल्कि मीन्स की तरह देखना होगा और जस्टिस डिलीवरी में सीमाओं को बाधा नहीं, मीटिंग पॉइंट के रूप में डेवलप करना होगा। और ये स्पिरिट को अगर हमें नीचे तक पहुंचाना है तो मैं मानता हूं अभी बहुत सारा काम करना बाकी है और इस पर सभी कॉमनवेल्थ कंट्रियों ने साथ में काम करने की जरूरत है। भारत ने इस क्षेत्र में ढेर सारा काम किया है। ट्रेड डिस्प्यूट्स के लिए और क्रिमिनल लॉ के कंप्लीट रिफॉर्म के लिए हमने बहुत लंबी चर्चाओं के बाद एक्सरसाइज कर सभी स्टेक होल्डर्स के साथ चर्चा कर भारत में इसका क्लेवर भी बदला है और इसका स्वरूप भी बदला है। और टेक्नोलॉजी का उपयोग हमने हर जगह पे इतना बढ़ाया है, सिर्फ अभी की उपलब्ध टेक्नोलॉजी नहीं, इनकी डेफिनेशन में हमने आने वाले 100 साल तक जितनी भी टेक्नोलॉजी में बदलाव आएंगे उसको डेफिनेशन में समावेश करने का भी हमने ढेर सारा काम किया है। मैं मानता हूं कि कॉमनवेल्थ कंट्रीज के लिए ये बहुत उपयोगी होगा कि हमारे यहाँ जो परिवर्तन हुआ है वो मैं मानता हूं आपके देश के अंदर भी बहुत सहायक होगा। आज जिस तरह से परिदृश्य बदल रहा है, मैं मानता हूं कि न्यायपालिका को भी बदलना पड़ेगा। क्रॉस बॉर्डर चैलेंजेस के मद्देनजर टेक्नोलॉजी का जो उपयोग है, इसको न्याय की पूरी प्रक्रिया में एडॉप्ट करना पड़ेगा। हम 19वीं सदी के कानून से 21वीं सदी में जस्टिस डिलीवरी नहीं कर सकते। और अब ये जो 3 कानून जिसका जिक्र सॉलिसिटर जनरल और लॉ मिनिस्टर ने किया, मैं कहना चाहूंगा कि ये 3 कानूनों के कंप्लीट इम्प्लीमेंटेशन के बाद भारत की क्रिमिनल जस्टिस सिस्टम विश्व की सबसे आधुनिक क्रिमिनल जस्टिस सिस्टम बनेगी। इसमें किसी को शंका रखने की जरूरत नहीं है। हमारी न्यायिक व्यवस्था में एआई आधारित ट्रांसलेशन व्यवस्था से बहुत सारा हमें फायदा हो सकता है और लीगल सिस्टम और केस की बारीकियां समझने में एआई का बहुत बड़ा उपयोग अब हम कर सकते हैं। कम्युनिकेशन और डॉक्यूमेंट एक्सचेंज का प्रोसेस भी बहुत स्मूथ हुआ है। ब्लॉकचेन टेक्नोलॉजी से क्रॉस बॉर्डर एविडेंस और भी ज्यादा अब सिक्योर हो जाएगा, इसका मुझे भरोसा है। परंतु दुनिया के सभी देशों ने ये सारी टेक्नोलॉजी को कानूनी जगह भी देनी पड़ेगी और कानूनी डेफिनेशन को भी, कानून में इसकी डेफिनेशन को भी जगह देनी पड़ेगी। भारत ने ऑलमोस्ट ये काम कर लिया है। आज के समय में जस्टिस की पूरी सिस्टम में 3 A यानी एक्सेसिबल, एफोर्डेबल और अकाउंटेबल, ये बनाना बहुत जरूरी है और ये तीनों के लिए मैक्सिमम उपयोग हमने टेक्नोलॉजी का करना चाहिए। इसका मेरा मानना है इससे बहुत सरलता होगी। मित्रों, जो नए कानून क्रिमिनल जस्टिस सिस्टम के 3 कानून हम लेकर आए हैं, उसमें हमने टेक्नोलॉजी को भी स्थान दिया है और इसके साथ साथ एफएसएल को भी स्थान दिया है। एविडेंस बेस्ड प्रोसिक्यूशन को बढ़ावा देने के लिए हमने 7 साल और उससे ज्यादा जितनी भी धाराओं में सजा का प्रोविजन है, सब में एफएसएल के ऑफिसर का, साइंटिफिक ऑफिसर का विजिट कंपलसरी किया है। और मैं आपको बता देता हूं कि कानून आने से पहले इसका पूरा इंफ्रास्ट्रक्चर और ह्यूमन रिसोर्स जनरेशन का काम भी एफएसएल यूनिवर्सिटी बनाकर हम समाप्त कर चुके हैं। जैसे ही कानून इंप्लीमेंट होंगे पूरे देश के अंदर ये व्यवस्था दूसरे ही दिन से हम आगे ले जा पाएंगे। मित्रों, आज एफएसएल यूनिवर्सिटी ने हर साल 35,000 साइंटिफिक ऑफिसर बाहर आएंगे, इस प्रकार की व्यवस्था हम ऑलरेडी कर चुके हैं। इसके पहले भारत के अंदर इंटीग्रेटेड क्रिमिनल जस्टिस सिस्टम ICJS के माध्यम से हमने देश के सारे पुलिस स्टेशनों को एक ही सॉफ्टवेयर से अपनी अपनी भाषा में ऑनलाइन काम कर सके, इस प्रकार का ऑनलाइन जुड़ाव कर चुका है। ई पुलिस के माध्यम से लगभग 8 करोड़ से ज्यादा लेगेसी डेटा को हम स्टोर कर चुके हैं। ई कोर्ट में 15 करोड़ से ज्यादा लोअर जुडिशरी के डेटा को ऑनलाइन कर चुके हैं। ई प्रिजन से 2.5 करोड़ से ज्यादा कैदियों का डेटा अब ऑनलाइन हो चुका है। ई प्रोसिक्यूशन से 1 करोड़ से ज्यादा प्रोसिक्यूशन का डेटा, लेगेसी डेटा की मैं बात करता हूं, नया तो अब ऐसे ही जनरेट होगा, वो ऑनलाइन हो चुका है। और ई फॉरेंसिक से माध्यम से 35 लाख से ज्यादा फॉरेंसिक का डेटा भी ऑनलाइन हो चुका है। ये सभी 5 पिलर्स, पुलिस, कोर्ट, प्रिजन, प्रोसिक्यूशन और फॉरेंसिक, ये सभी 5 पिलर्स के लिए इंटर पिलर इंटीग्रेशन के लिए भी AI का उपयोग करते हुए सॉफ्टवेयर एक साथ बन रहे हैं और ये 5 का डेटा एक दूसरे के साथ बात करे ऐसी ही भाषा में पहले से ही बनाने का काम हुआ है, जिससे जब AI के उपयोग से सॉफ्टवेयर बन जाएंगे तब ये सारा डेटा एक दूसरे के साथ बात कर ढेर सारी चीजों को सरल कर देगा, इसका मुझे विश्वास है। और मैं आज ये कॉन्फ्रेंस के अंदर हमारे देश के भी काफी लॉयर आए हैं, काफी बनने वाले लॉयर भी यहाँ पर उपस्थित है। मैं सबको विश्वास दिलाना चाहता हूँ कि ये तीनों कानून का कंप्लीट इम्प्लीमेंटेशन होने के बाद किसी भी FIR को हाई कोर्ट तक 3 साल में न्याय मिल जाएगा, इतना हमने सुनिश्चित कर दिया। मित्रों, आज हम सब जब यहाँ उपस्थित है तब मैं इतना ही कहना चाहता हूं कि आने वाले दिनों में यहाँ पर जो भी विचार मंथन हुआ है वो विचार मंथन एक्शनेबल पॉइंट में कन्वर्ट हो और वो एक्शनेबल पॉइंट लॉ मेकिंग एजेंसी तक जाए और लॉ में सार्थक परिवर्तन कर आने वाले दिनों में दुनिया में ट्रेड और क्राइम कंट्रोल दोनों को टेक्नोलॉजी के उपयोग से हम कर पाए। ये विश्व की जरूरियत है, कॉमनवेल्थ कंट्रीज की भी जरूरियत है और भारत की भी जरूरियत है, क्योंकि कोई देश अब एक दूसरे के साथ जुड़े हुए कानूनों के बगैर अपने देश को सुरक्षित नहीं रख सकता। इस वास्तविकता को हमने समझना भी पड़ेगा और इसको स्वीकारना भी पड़ेगा। मुझे लगता है कि आज की कॉन्फ्रेंस इस दिशा में बहुत फ्रूटफुल होगी और आने वाले दिनों में कॉन्फ्रेंस के सुफल पूरे कॉमनवेल्थ कंट्रीज में हम देख पाएंगे। मैं आप सभी को बहुत बहुत अनंत शुभकामनाएं देकर मेरी बात की समाप्ति करता हूं। वंदे मातरम।
May I now request the Honourable President of India, Srimati Draupadi Murmu, to please address the august gathering.
Shri Amit Shah ji, Union Minister of Home Affairs, Chief Patron of Commonwealth Legal Education Association and Judge Supreme Court of India, Sri Justice Suryakantji, Union Minister of State for Law and Justice, Sri Arjun Ram Meghwalji, Attorney General of India, Dr. R. Venkataramaniji, Solicitor General of India, Sri Tushar Mehta ji, President CLEA, Professor S. Shivkumarji, Attorney Generals and Solicitors from Commonwealth countries, Advocate Generals, members of Judicial Fraternity, distinguished guests, ladies and gentlemen. I am glad to be here in the August gathering of attorneys and Solicitor Generals, other members of the legal and judicial community, and legal scholars from the Commonwealth nations. Many of you have come from far, and all of you have given 2 days for brainstorming over a matter of critical significance, namely cross-border challenges in justice delivery. I hope you have had memorable formal and informal discussions and fruitful sharing of ideas and experiences during the conference. I see before me some of the best minds of the legal fraternity from around the world, while you have deliberated on various topics on the agenda in precise specifics and great details. I can only offer a general and generic overview that may complement your ground level understanding of the situation. Let me ask the basic questions. What does justice mean? The great Indian knowledge tradition offers a range of answers. The Sanskrit term closest to justice is nyaya, which means both what is just and what is right. Nyaya is also the name of one of the 6 systems of classical Indian philosophy, which is essentially similar to the study of logic in the West. So, what is right and just is also logically sound. These 3 qualities combine to define the moral order of a society. That is why you, the representatives of the legal profession and the judiciary, are the ones who help in upholding the order. If that order is challenged, you are the ones who, as lawyers or judges, law students or teachers, strive most to set it right again. As many of the educators and students in the field of law here know, nyaya was one of the fundamental elements of education in ancient India. This age-old conception of justice continued to be reflected in the justice delivery system at the village level in India till the advent of modernity. In modern times, 2 or 3 generations of exceptional leaders helped revive a new national awareness. What was very noticeable then was that a majority of them had studied law, and that too in England. I am sure many of the other Commonwealth members had leaders in those days with these backgrounds. This legacy is what binds us together as a family. The obvious reason of this common pattern is that any effort towards the foundation of a modern nation has to begin with a common understanding of justice. This process, in formal terms, leads to the writing of the Constitution. India was blessed to have Dr. B.R. Ambedkar as the head of the drafting committee of the Constituent Assembly. He expanded the notion of justice. His conception of justice is, I believe, relevant not only in India, but in all parts of the globe. The preamble to our Constitution speaks of justice, social, economic, and political. Therefore, When we speak of justice delivery, we should keep in mind all aspects of it, including social justice. In recent times, as the world faces the threat of climate change, we should also add environmental justice to these varied aspects of the concept of justice. As it happens, the issues of environmental justice often pose cross-border challenges. They form the key area of what this conference is about, namely cross-border challenges in justice delivery. Dear friends, our environment is only the most obvious way in which we all are interconnected. Globalization of trade and commerce is another example of this interconnection. Moreover, in recent decades, technology has brought us closer to one another. When we explore the complex cross-border legal challenges, we need to keep two things in mind. Firstly, humankind has a long and rich history of interconnection and interdependence. Secondly, the technological revolution has once again highlighted exactly the interconnectedness. This often leads to challenging situations in law, but we should always be guided by what is common to us all: humanity and humanitarian values. I am glad that the Commonwealth Legal Education Association has taken this responsibility to chart a roadmap to a common future that transcends borders and interlines the fundamental principles of natural justice based on equality and dignity. I believe this is an ideal forum for the necessary collaboration. The Commonwealth, with its diversity and legacy, can show the rest of the world the way to address the common concerns in a spirit of cooperation. India, as many observers abroad have also noted, has emerged as a key stakeholder in the global discourse. I am confident that India has much to offer when it comes to international issues in justice delivery. India is not only the biggest democracy, but history shows that it is also the oldest democracy. With that rich and long democratic heritage, we can offer our learning in justice delivery in modern times. Dear friends, as I was going through the agenda for this conference, I was glad to see that a careful selection was made for sub-themes, including a subject close to my heart: access to justice, bridging the divide. I will be glad to see the Commonwealth nations exchanging their experiences and lessons in this domain. The discussions in the conference must have been enriched by the participation of deans and vice chancellors, as well as senior students and scholars of various institutions and universities. Young minds are flexible and can offer innovative and out-of-the-box solutions to the problems that have challenged the most experienced professionals. Young people are also most at ease with new technologies that can offer new solutions too. Among the sub-themes, I was happy to note ethics and accountability in legal practice. I could not help but recall the incident from the life of Mahatma Gandhi. Incidentally, it was his study of law in London that changed his destiny and also the destiny of countless others. He had gone to South Africa to assist in a legal dispute and eventually found a way to bring the two parties to an agreement. They both welcomed his solution happily. In his autobiography, Gandhiji writes, and I quote, "My joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and to enter men's heart. I realized that the true function of a lawyer was to unite parties, even asunder. The lesson was so indelibly burned into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Amid the endless complexities of laws and statutes, let us never forget the simple and basic goal before us, which is to find out the better side of human nature. Dear friends, I extend my heartful appreciations to all participants who have gave their time for this event, shared their wisdom, and enriched the discourse. I also congratulate the organizers of the conference for creating a platform that can be a template to launch similar initiatives in matters of common concern in the legal and judicial domains. To all of you, I offer my best wishes. Thank you. Jai Hind, Jai Bharat.
Ladies and gentlemen, kindly rise and remain standing for the national anthem. Thank you, ladies and gentlemen, for joining us for the Commonwealth Attorneys and Solicitors General Conference. Thank you for your participation and invaluable inputs. Kindly remain in your places until the President and other guests have left the dais. Please join us for tea and refreshments in the atrium. You can use